Good morning, everyone. Madam Registrar, please call the matter.
Thank you, President. The Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana. Hearing of the matter GYCV number 4 of 2025 between Cara Investments Limited and Christopher Ram and the Bank of Nova Scotia. The members of the hearing panel are the Honorable Mr. Justice Anderson, President and Presiding Judge. The Honorable Madam Justice Rajnath Lee. The Honorable Mr. Justice Jamadar. The Honorable Madam Justice Ononiwu. And the Honorable Mr. Justice Ibo Suji. Counsel, you may now enter your appearances.
Good morning, Your Honors. I am Sanjeev Datadin, and with me is Ms. Mohani Anganu and Mr. Samuel Glasgow, and we appear for the appellant, Cara Investments Limited, and Mr. Sean McGrath is here from Cara Investments.
Thank you, Mr. Datadin.
Your Honors, Neil Boston, I appear for Christopher Ram, the first name respondent. My junior, Mr. Rion Miller, unfortunately had to disembark because he was informed that his grandmother was undying. She didn't have more than a couple of hours to live. So I will seek the benefit of Mr. Ramkarans Jr. in my presentation.
Thank you, Mr. Boston. Our sympathies, of course, with Mr. Miller. Thank you. Thank you, Mr. Ramkaran. Well, Counsel, we are ready to proceed. Mr. Datadin, please. We have a couple preliminary matters to raise with you,
Yes, Monsieur.
and this will not be counted against your time.
Okay.
You'll be happy to hear, and you'll be also happy to hear that we will give you more than the 60 minutes if you so desire, and of course, whatever time you take above the 60 minutes will also be afforded to the parties.
Your Honor, I'm always happy to hear that, but I'm a little worried too.
Yes, we like to keep you happy if we can. So I'm going to ask just a couple of questions because there's something that's bothering me about this, and I believe one or two of my colleagues may have similar questions, and then when we're finished, we'll start with your time. Can you confirm that this matter started in the year 2000?
Yes, sir. 25th of February 2000. I will check. That was when the statement of claim was filed.
Yes. The actual month isn't that critical. It's 2000, yeah? 2000, year 2000.
Yes, Your Honor.
Okay. And we are now at the year, is it 2025?
Yes, Your Honor. A quarter century.
Indeed. And I gather that one of the judges who was involved in this matter when it started was our very own Justice Desiree Bernard of blessed memory. I think at the time she was the Chief Justice.
She was. That is true, Your Honor.
And then I think that another judge who had some involvement in this case was Justice Kisoon.
Yes, Your Honor.
BB ordered the adding of the bank as a defendant.
Yes, he did, Your Honor.
And that was done in in 2000 as well?
Yes, please, Your Honor.
Okay. And I gather Justice Kissoon is also of blessed memory.
Yes, he is, Your Honor.
I believe as well there was an injunction granted in this case by Justice Singh,
Justice Jainarayan Singh, yes, sir.
and that was dated sometime in June.
Justice Moore, yes, Your Honor.
Is Justice Moore with us?
No, please, Your Honor, he has passed away.
I believe that the trial judge in this matter was Justice Chang, who gave a decision on the 7th of June, 2012.
Yes, Your Honor.
I believe Justice Chang is also of blessed memory.
Justice Chang is no longer with us, Your Honor.
So this case seems to have survived quite a number of our legal luminaries.
It has, Your Honor.
And I gather that the persons who have passed away during the course of this matter extend beyond the bench, and that some of the lawyers involved. So, for example, I gather Mr. Aston Chase,
Senior Counsel Ashton Chase, yes,
Senior
he's no
counsel.
longer with us.
Sir Fenton.
Sir Fenton is also no longer with us.
Is there anyone else who participated in this matter as counsel who is no longer with us?
Mr. Mackey.
Mr. McKay was one of the initial attorneys involved. And in the High Court, the bank was represented by Richard Fields, senior counsel. He is also no longer with us.
We're happy that you are with us.
I'm very worried that the trend.
I think we'd better get on with this case, Mr. Datterton, and do the judgment quickly.
But I hope you see the point I'm trying to get at.
Yes, please, Your
This matter
Honor.
has been with us a long time,
Far too long.
far too long. And it surrounds, to all appearances, a fairly simple point, which
We
has
believe
to
so.
do with an unsuccessful bid to purchase a hotel. There are other factors which come in, but at bottom,
Yes.
isn't that what the matter is about?
Simple.
So
yes.
can you explain to me, Mr. Datterton, how is it that this matter, involving an unsuccessful bid to purchase a hotel, has occupied judicial time for 25 years?
Your Honor, if I had an answer that would be worthy, Your Honor, I
We
would.
cannot go on this way, Mr. Datterton.
No, please, Your Honor.
We cannot.
No, please.
I don't think Guyana can or should. I don't think the Caribbean can or should. We are a serious society, and we handle matters expeditiously. 25 years is not expedition as far as I'm concerned.
No, please, Your Honor. I used to.
There is a movie which came out recently, which I have not seen, but I've heard of, whose title is It Ends With Us.
Not familiar, but I'll take the court's word.
Thank you for taking the court's word. And I assure you that this is one way or the other going to end with us. We cannot continue like this. And I don't know, I suppose there are rules which allow for the continuation of these kinds of matters in this kind of way, but this court is not impressed at all by it.
Your Honor, to answer the court, there are no rules that allow for the continuation of the matter in this way. It is a tragedy that most of what happens is, I would hate to say laissez-faire, but Your Honor, in this particular matter, we got the Court of Appeal reasons through this court's assistance 2 days ago, I believe it was, on Thursday of last week. It was only then that we got the reasons in the Court of Appeal.
I see. Okay, I don't know whether
Mr.
any of my
Datterton, can I
colleagues have-
just follow up on that a little bit? So, did you make inquiries prior to yesterday for the transcript of the proceedings before the Court of Appeal? Because you
We had the
an
transcript
oral-
for some time before, but we only got the reasons. We only got the transcript, Your Honor, when I was last in this court. I made an appointment with the registrar in the Court of Appeal, and I went and I personally asked if we could have any assistance because it was now coming. And in the last matter, not to raise too much about, but in the last matter, the issue of the transcript was something that this court made comment about and was examining. And I was really, really bent on trying to get it and to get one that was...
What I really want to get to is something a little more pointed and relevant maybe to what we have to do today, which is, I notice the judgment of the Court of Appeal is dated the 7th of June, 2024.
Yes, please, Your Honor.
Obviously, you didn't get it around then. You only got it 2 days ago. So
Your Honor,
my question is this. When you read the transcript and you read the judgment, is there anything in the reasoning that is different from what appeared in the transcript and what appears in the written judgment that is of relevance to what we have to do? Because you reserve the right in your submissions to add grounds upon receipt of the decision of the judgment of the Court of Appeal. You got it 2 days ago, but you had the transcript for a little while. So I just want to ask, given that as I said, the judgment is dated June 2024, you got it 2 days ago, is there any difference between the two in the reasoning?
Your Honor,
You read it?
yes, please, Your
Okay.
Honor. Your Honor, if I may, respectfully, and not meaning to be rude, the verbatim transcript that we received and read versus the reasons for the decision of the court. The reasons for the decision include and go into the matters that we did not see dealt with in the...
Matters that you, sorry, what?
Did not see, for example, Your Honor, the issue about whether or not Justice Moore's decision was one that was binding, and because there was no appeal to it. But to address what the court is saying, Your Honor, two things.
What I'm trying to work out is this. Given that factual scenario,
Yes, sir.
you said that when you receive the Court of Appeal decision, you reserved your right.
Yes, please, Your
So
Honor.
I'm asking, are there differences? You say there are. So what I want to know is it that you intend this morning to raise any new submission based on what you have now seen in the decision of the Court of Appeal? I'm just trying to be fair to you.
Not entirely new, Your Honor. There was one decision which we filed our speaking notes yesterday for the specific purpose of being able to raise one issue.
All right, so when you come to that, would you just highlight
Yes.
for us that you're raising this because it has, in your opinion, it has arisen anew on your
Yes, please,
side
Your
of the
Honor.
Court of Appeal decision?
Yes, Your Honor.
Okay.
I will do that.
Good. One last thing I want to ask you. The share transfer took place when?
2003, I believe.
Yeah. And has that business therefore been running?
It has moved on,
Yeah.
by my understanding, through...
So that's 20 years ago plus.
Yes, please, Your Honor.
Yeah. So what is the ultimate relief you want from this court in this
It would
matter?
be damages in the...
That's your loss of opportunities argument?
Yes, please.
All right. Okay.
Yes, please, Your
Yeah.
Honor.
Okay, good. Thanks.
Yeah, at one stage in the, I'm sorry, my brother, please, go ahead.
Go on, please. After you go.
No, just to follow up on the damages issue, at one stage, I thought Sir Fenton was asking for damages
Yes, please, Your Honor.
in excess of $12 million US.
Approximately 14 million was the number.
14 million US.
Yes, please, Your Honor.
Okay, good. Thanks.
Just a technical procedural question. You said you read the verbatim transcript. Where is it in the record, please, so I can...
Pardon me, Your Honor?
Where in the record of appeal do we see the verbatim transcript? You said you have received verbatim transcript?
Your Honor, it is not in the bundles because it wasn't, when these bundles were filed and prepared and done, it was not done. The court received, I believe, through the industry of the court was able to secure a verbatim transcript from the Court of Appeal. We did not receive that. That was sent to the court.
All right.
And the court posted it to the portal and sent us an email. And that's how we became aware of the availability.
Fair enough. So we are talking about the Court of Appeal.
Yes, please, Your Honor.
But what we do see at Appeal Record page 226, Appeal Record page 226,
Yes, please, Your Honor.
that is before the High Court, the trial, right? Now that we will not call verbatim transcript, would we?
Your Honor, that was what we obtained in the Court of Appeal from the High Court.
Yes.
That was Justice Chang's, Acting Chief Justice Chang's notes of evidence.
Ah,
So there was a trial, this is his notes of evidence
all right.
that we obtained from that court.
Thank you. I
Thank you,
just
sir.
wanted to nail that. Thank you
Thank you,
very
sir.
much.
Okay, so I think you're on the clock now. Thank you.
Thank you very much, Your Honor. Your Honor, the respondent, Christopher Ram, the first respondent, pursuant to the benches, was appointed a receiver on the 9th of April, 1999, over the assets of Hotel Tower Limited. Your Honor, that letter of appointment is at page 538 of the record, and it's from a Mr. Cooper, who was at the time an officer of Scotiabank. Following that letter of 9th April, Mr. Ram approached the court, and there is an order at page 567 by Chief Justice Bernard to confirm the appointment of Mr. Ram as the receiver, and that order is the 14th of April, shortly after. Your Honor, we say that, and we'll come back to it, but at that stage, please, Your Honor, Mr. Ram, as the first respondent, was an officer of the court because he had been appointed as an out-of-court receiver. He chose to have that confirmed by a judge. So the judge confirmed that he had an authority to act as a receiver. And Your Honor, we'll come back a little bit to that. Now, the first respondent, which is Mr. Ram, placed an advertisement in the papers, which is intituled, it's at page 577, of the record. Your Honor, you could see here, it says, request for proposals. And this was published on Friday, 12th November, 1999, in the Stabroek News. But as could be seen from this request for proposals, it was not actually in this publication a request for proposal itself, and both courts have made comment about it. And it says essentially what it was doing is the receiver manager, which is the first respondent, is announcing that he will be commencing the request for proposal process, and that to sell the assets of Hotel Tower pursuant to debentures. And it goes on at the bottom, potential investors who submit an expression of interest qualify to receive the request for proposal to access the document room, which will be opened on a date, 24th November, in the argument. And that was one of the issues, that specific paragraph. Paragraph 35 of the Court of Appeal decision, the written decision.
So
Your Honor,
your point being that what we just saw on the pages of the Starbrook newspaper
yes, please, Your Honor.
was not an RFP. It was basically called for expressions of interest.
Yes, please, Your Honor.
And the Court of Appeal treated that as if it was the RFP. Is that your point?
That is what we will submit to the court.
Thank you.
Your Honor, what happened following that is there was a second advertisement, identical, on the 17th of November at page 578 of the record. Identical terms, identical content. Now, the appellant at page 5, so this is the second one, identical. Now, at the next page, 579, the appellant, Cara Lodge, and they enclose a check in that amount. What they indicated here is it said that potential investors who had already notified the receiver of their interest need not do the same. But they were confirming that the receiver was aware that they had in fact done so already. Now, in November, as could be seen at page 368 of the record, there was a preliminary information package produced. And that preliminary information package was dated or had on its face May 1999. But in fact, it was in November. These were the documents that were being referred to. That preliminary information package contained, which is at page 368 and onwards of the submission, I don't want to say background information, but it provides what the hotel was about, what business opportunities, what the structures, what the facilities were. And was in fact what would be considered and traditionally the request for proposals. Now that request for proposal, if the court were to look at page 396 of that at 0.1.3, this request for proposal, it states, this RFP is issued to invite sound formal proposals from investors to bid for the assets of Hotel Tower Limited pursuant to 3 debentures, of which security, it goes on. Investors will be required to submit their proposal as far as possible in the format laid out, which may be subject to changes, and essentially they will be informed.
I'm sorry, Mr. Dutton, is this the document in which the cancellation clause is?
Yes, please, Your Honor. And that is at page 399, 2.2.6. The receiver manager is not bound to accept any of the proposals submitted and reserves the right to...
Cancellation clause.
Yes, please, Your Honor.
Okay.
But if we look at what is contained below, at proposal submission requirements, they are 3.3.2, the requirement of a cover letter. It goes into numbers of copies, offer price, investor conceptual framework. But 3.2.1 said, Schedule A should state a guaranteed minimum purchase price for the security which is subject to the debentures. Investors should discuss the basis of the valuation to be acquired, underlying assumptions, and how any change in Hotel Towers Limited would business or assets would affect liabilities prior to the completion. It requires breakdown of investor capacities, and it goes through various matters which we will come to, Your Honor.
So these are all components of the bid.
Yes, please.
To
Your
be
Honor.
compliant, it would have to comply with those conditions.
Yes, please, Your Honor.
But is that not controlled by 2.6?
Yes, please, Your Honor. Absolutely. But, well, if I could just do one more document and then
Sure.
answer the court with 2.6. Your Honor, we have it? Yes. And, Your Honor, there is the bids for Hotel Tower, which is the proposal by Cara. Your Honor, at 440, it might be easier to follow it because it's in chronological order there. Your Honor, as could be seen, there is an executive summary as required, an offer price, a guaranteed minimum, a basis of the valuation, clearing of the debt to Scotia Bank, total investment, $3 million, which is at page 444. It outlines these issues. It has the approach, and included in it is a survey and a guarantee of finances, matters that are concerned with the bid that was submitted. Now, Your Honor, it says, subject to due diligence, and much is made about that as to whether it is conditional or not in the submissions from Scotia Bank and also in the Court of Appeal made reference in that decision. But Your Honor, if we go back at page 403 of the record, which is in the proposal, the bid says in the proposal, the bid says we would do this subject to our confirmation on due diligence. But Your Honor, to answer the question or to answer what was posed by the court about the cancellation clause, Your Honor, in the evidence in the High Court, which page 255 of the record, where this is the proceedings before Justice Chan. The evidence of Ram. He says repeatedly that Your Honor, at page 262 of the record, the 1, 2, 3 paragraph, I was never able to take any further steps in the sale of the assets. Shortly after the proposals had been submitted to Nova Scotia, Cara Investments initiated legal proceedings served upon me with an order from Justice Kissoon. Justice Kissoon's order was an application had been made for an injunction, and it was a service order. There was no order made. He goes on, I gave undertakings in the next paragraph not to dispose of the assets until the determination of the application for an injunction. Your Honor, I have no record that any such thing occurred. I believe what is being referred to is the order of Justice Jainarayan Singh, which we will get to in a minute. But Justice Jainarayan Singh's order doesn't say that he can't do anything. It says you can't take any steps or do anything unless you comply with the RFP that you issued. So at that stage, respectfully, Your Honor, the first respondent, Ram, knew that he had to
Mr.
comply.
Dutton, can you pull up the order so we're all looking at it?
Yes, yes,
So
please,
you're not-
Your Honor. The
You're not
order,
paraphrasing it.
one second, Your Honor. 182 of the record, please, Your Honor. I think it is on screen. I hope this is not the one I wrote on. Yes.
Normally, just a procedural question. There are some jurisdictions where when counsel brings a motion to the court, the counsel must also come with a draft order to.
Yes, Your Honor.
Is that the same in Guyana? Do you have to attach a draft order when you make a motion to the court?
Your Honor, it is now definitely the case. At the time in about 2001, my recollection is not so much the case because the registrar would be, the court would usually write and it would go, but it is not uncommon, Your Honor, that a draft order would have been submitted. It is now part of our rules that has to be done.
Were you the one who submitted the draft order in this that we're looking at now? Was
No,
that your
please.
draft order?
No, please, Your Honor.
It wasn't your draft.
This was the court's order,
I know.
and what was ordered was that the defendant, the last few lines, the defendant by himself, his servants, and otherwise, be restrained from awarding or allocating the purchase of Hotel Tower Limited until the defendant complies with the request for proposals dated November 1999 until the hearing and determination of the cause. So the order that was sought didn't stop him from treating with what he was doing. He simply needed to act in accordance with the RFP. Now, at that...
What is the last sentence there, or the last phrase telling us? I mean, we see, it looks like a run-on sentence there. We see, and is the occurrence of the word until
Yes.
twice that makes this thing read like a run-on sentence. But let's look at the last until the hearing and determination of this cause. What is that telling us?
Your Honor, in matters that were interlocutory, meaning they were not meant to be final orders and they will exist and subsist until the final hearing of the matter, this order was intended to take effect to that, which means this order at the hearing, the judge would have so for example, it would be an injunction is granted that you do X until the hearing and determination of the trial. And this was an injunction granted that you comply with X until the hearing and determination of the trial.
Yeah, so that's what the last, until the hearing and determination of this cause, matter.
Yes, please, Your Honor.
That's right. This was ex parte, right? This was an ex parte order, I believe. It says so. Upon reading
Yes.
but right. So was it an ex parte application granted ex parte, or was it because you can say, you can make an application. Very often, we would receive ex parte applications, as you know, and as a trial judge, you treat it, you say, let us hear it inter partes. So I'm just trying to clarify, was this ex parte done ex parte, or was it an ex parte application done inter partes?
Your Honor, in my memory of going through it, I know there is an order where Justice Jaina Reinsing...
Parties hearing.
Yes, Your Honor.
So therefore, the bank was not as yet involved. The
No,
bank,
please, Your Honor.
right, but the receiver was.
Yes,
That's why
please,
it's
Your Honor.
intituled as it is.
Yes, please, Your Honor.
Okay.
So, Your Honor, if I may just, under the old rules that existed, if you made an ex parte application and the judge ordered service, what you did is you served that same application.
Yeah, no, Mr. I'm well familiar with the RSC
Yes.
rules. Thank you.
Yeah,
Thank you,
Mr. That is one thing, because you mentioned that Mr. Ram said in his evidence that he had given an undertaking. This application by Davina Stevenson was filed on the 26th of January, 2000. What happened between that time and this order, which was made on the 16th of May, 2001? I ask that because I'm saying, is it likely that there was that undertaken given
Your Honor,
by Mr. Ram that held this matter over for that length of
Your
time?
Honor, if there was such an undertaking on the record, Your Honor, I'll stand corrected if it is somewhere on the record, but I don't have any recollection of reading that, and I know the issue was raised in the first court, in the second court, and this issue about whether an undertaking had been given was raised in all three courts, well, all the two courts below, and there was none on the record at that time.
Yeah, could I ask one? Could I
I'm
ask
still-
one question?
Yeah.
in
Yes, please, Your
follow-up to
Honor.
that? Was there any evidence to contradict Mr. Ram's evidence that he had given this undertaking? Just so that I could clarify that. Aspect.
Your Honor,
Does really an interpretation of it, because it seems to me that it is a very critical aspect of this case. Now, is it correct to say that that order, that injunction order, follows your prayer in clause H of the writ of summons? Can you pull it up? If you can go to page 76 of the appeal record. See whether that gives us a
yes,
way
please, Your
to-
Honor.
Yes, you say yes.
That's where it was grounded, yes.
Yes, and it says there, paragraph H, I believe, an injunction restraining the defendant by himself, his servants and/or agents from awarding and/or allocating the purchase of Hotel Tower Limited until an inquiry is concluded at the instance of the court as to the propriety and conformity with the law of the bidding.
I do have a question about it. Going back to this question of how to interpret it, and I do understand that my colleague just referred to the prayer. I have a pointed question. Do you interpret this injunction as restraining the receiver or manager from terminating or abandoning the request for proposal process before the determination of the matter? So I'm going back to clause 2.6 in the request for proposals.
Yes, sir.
It not only allows or gives the requester the freedom not even to award a contract, but it allows the requester to terminate the process at any time. Do you interpret this injunction as preventing the receiver or manager from terminating the process? So we're clear. It requires the receiver or manager to act in compliance with the RFP. I'm not questioning that. What I'm asking is, do you interpret this injunction as preventing the receiver or manager from not pursuing this process?
Your Honor, the simple answer would be, or my respectful submission to the court is, in my reading of the order, it was to do anything in the request for proposals, including 2.6. So if he had taken or if he had done anything in accordance with the request for proposals, then he would have had not fallen foul of what was contained here. But, Your Honor, that goes with a corollary, the duty to act fairly. We mentioned the principle of reasonableness. The simple authority that you have to conclude or to cancel a tender does not mean you can do it arbitrarily. You have to have a basis for it. You must inform those that are involved. And he never did that at all. That is not disputed. He never exercised his power of cancellation. Up to now, there has been no exercise of that power. He simply stopped and he went and engaged in selling the shares, which as a receiver he had no authority over. He had an authority over the assets of the company. The shares belong to the shareholders.
Now, Mr. Dattadin, I really don't want to jump ahead, but you've opened the door to something I need to interrogate, because a core part of the appellant submission is that the sale share transaction violated the injunction. That's a submission that Cara Investments has made, that the sale of the shares violated the injunction, and you've now noted that that transaction, if I understood you correctly, goes outside the remit of the powers of the receiver manager.
Yes, please, Your Honor.
Okay. Now, I just have a question as a follow-up. I don't think this will take you outside of the scope of an argument. I know you want to make some more, but when I look at the debentures, there are 3 debentures, and
Yes,
they
Ms.
have
Chairman.
quite similar provisions.
Yes, Your Honor.
And it would appear that the powers of the receiver are quite wide.
Yes, please, Your Honor.
And Mr. Ram was appointed not only a receiver, but a receiver manager. And the
Yes.
Companies Act of Guyana sets out clearly what the responsibilities or the ambit of not just a receiver, but a receiver manager are. So the question that I have is, can you clarify, in light of the powers of the receiver manager under the debentures and the role of a receiver manager under the Companies Act, why you say the sale transaction was outside the scope of the powers of Mr. Ram as debenture, as receiver manager?
So, Your Honor, this is what happened. He's appointed receiver over the assets by the letter of 9th April by the bank. He goes to the court on the 14th of April and obtains an order that he is appointed the receiver manager. The Companies Act provides, notwithstanding what is contained anywhere else, that a receiver manager has a duty to act fairly. I believe it's 278 of the Companies Act in Guyana. We then have, with every contract, the Borganza principle, which is Wensbury reasonableness in public law. I shouldn't say that, Your Honor. I will just say that I treat it in my mind as Wensbury reasonableness in public law coming into contract law. And that you will have a power to do certain things. There is inequality in every bid process, that the person soliciting the bids can terminate at any time. But he must act reasonably. And that is why our submissions as it relates to contract A and B, which is the British Aerospace Blackpool case, once you have submitted a tender, a bid, it has to be fairly evaluated. You could lose.
It has to be fairly evaluated, even if the terms under which you presented the bid are that the tenderer can terminate at any time.
Yes, Your Honor, because if he exercises that authority,
Yes.
he is obliged to tell those who have come to submit. This receiver made everyone, it is the way he treated this. He did.
Could he have excluded that obligation that you are going to speak about? Could he have said, well, there's no obligation on me to notify the bidder? Could he have done that?
If he didn't need to notify the bidders,
That their bids have been discarded, we're not going to consider.
respectfully, no, Your Honor, because under the RFP which he has invited people, he says, I have the power to do this. But he must inform them, he must say to them that I'm not accepting. The receiver is not bound to accept any proposal submitted and reserves the right to reject.
Because the argument I'm hearing, and the respondents would have to confirm that, My reading of the material and including the records seems to me that they're arguing that Cara Investments litigation was premature in the sense that Cara Investment requested an extension of time within which to tender their bid, regardless of who's caused that extension to be made. The point being that there was an extension of time, and while that extension of time was still pending, Cara Investment commenced litigation. The reason they said it was premature, not only commenced litigation, but followed up with an injunction that told Cara Investment, do not proceed on this bidding process anymore until the court has determined the propriety of your proceeding.
Your Honor,
And they said that that is where the thing was stuck. So if that is where the thing was stuck, would you really say that if, as we speak, even today, that they have cancelled the
respectfully no, Your
process?
Honor. Respectfully no, because the order, the injunction, the direction of the court, however termed, was comply with the RFP. So he, the receiver, had every power under this RFP to exercise at his disposal.
But that's a matter in
He
dispute,
says in
though.
his evidence,
You see, it's in dispute because they are saying,
he, the receiver, has acted.
and there's a dispute about that. They're saying, you're saying they didn't comply, they're saying they complied.
No, please, Your Honor, there is no dispute. He said he didn't act because he gave an undertaking to the court. That is not so.
That's the reason the litigation started, wasn't that?
The reason the litigation started is because Cara was alleging that he was acting outside of the RFP. So the court said, act in accordance with the RFP. If he wanted at that stage to say no more, no mass, finished, then he could say, I'm exercising the powers for these reasons.
I want to take you up on that, Mr. Datadin, to go back to what our president asked. I think it's important. You say there was an obligation to notify the bidders. Is it that you find in this obligation in the documents, or is it that you finding it in some authority, some case? I'd be interested to see it.
Your Honor, the duty to act fairly, which exists, would be to tell people who are, you have put out a bid, you have put out a request for proposal, you've gone through a process, confidentiality agreements, notification, payment, document room, take in copies. You then do a request. It is finished. The Borganza principle is very clear that in a contract, it will be implied into every arrangement that the duty to act fairly exists. But this also goes to what the Companies Act says. The receiver is obligated to act fairly. Fairly means you must tell those that you have invited, because he didn't do it to the public at large. He put the advertisement for those interested to be investors to inform him. They then went through that process. Only those persons received the actual request for proposal.
Mr. Datadin, I want to explore a bit further with you the contours of this duty to act fairly. You've clearly set out in your submissions that in the circumstances of this case, this process contract, let me use the term broadly, would have arisen. And you've said that a key undertaking of the tenderer, the requestor, would be this duty to act fairly. I want to draw your attention to clause 8.0
Yes, please, Your
in
Honor.
the request for proposals. And I want to understand the interaction of this clause with clause 2.6. So clause 8.0, the last sentence, says that the results of the evaluation will be communicated to an end. Doesn't really accept any of the bids, may pursue some other course of action, which is which the requester is entitled to do under clause 2.6, what, if anything, would come into play where clause 8.0 is concerned?
Well, respectfully, Your Honor, if I may submit my understanding of what I understood would have happened, because in bidding processes or in the process of bidding, there is recognized to be two parts: a contract A, which is the part where you respond, and then contract B, which goes on, is where you're informed about you being successful or not. But the contract A happens when when the bid is received by the entity, the person requesting that bid. The obligation to act fairly and the obligation to treat with it in accordance with the terms of the RFP would arise. If at that stage he were to say, we do not want to do this anymore, then he could say that for this reason he is not doing.
Why would he have to give a reason?
But, Your Honor, because if it is, and we accept that in the bidding process there is the contract A when you receive versus the contract, they would be right.
With respect, you're reading clause 2.6.
And he can then say, I exercise.
Correct. So can't you indicate by virtue of the language that you use that you do not intend for there to be the emergence of a contract A?
Your Honor, if we're to take that out of the equation entirely,
Take what out of the
the mention of contract A and contract B,
Okay.
then we have a simple arrangement. And for a moment, if we look at it from the point of view that Mr. Ram has put out RFPs, he's put out these rules. There is no court order, there is no anything else. He's put out these rules. Right. Then the expectation is, in accordance with these rules, he will act, or his behavior is going to be prescribed by what is in these rules. If he chooses to say that he is exercising 2.6 to cancel the process, then he must do something. A smoke signal, wave a flag, but he must say to people, it's at an end. He can't say he did nothing. And by implication,
knowledge or something like that, would that have satisfied you? Would that have?
Well, Your Honor, it would be within the terms of what he would say.
So with that kind of sentence included, would you still say that he would have an obligation to notify unsuccessful bidders?
If he is exercising the power of terminating the process, then the unsuccessful bidders and those issues would not be the driving force. It would be
so
that
is the answer to my
everybody has come
question
to
yes? That had he included that sentence or something to that effect, then you would have no ground to argue that he had breached a duty to act reasonably or to inform the bidders.
Respectfully, Your Honor, I see what the court is saying, and I agree, subject, Your Honor, to one very important corollary to it. At that stage, Your Honor, under any circumstance, even if we were to do the contract A, contract B, whatever, the evaluation would have taken place, the duty to act fairly would have been met, the consideration of what was submitted to him would have been satisfied. So yes, he would have gone through that process and say, well, nobody's made the mark.
Well, Mr. Data, then the 2.6 say you can stop at any point. You don't have to go through an evaluation process. You want to put it back on the screen for us, please? Doesn't it say that the
completed proposals to be delivered by this date and time?
Yes.
Late proposals not accepted. All proposals submitted in a timely manner will automatically be considered remaining valid for 60 days after the closing date.
So are those subject to 2.6?
They are subject to 2.6, Your
Okay.
Honor.
Put another way, are you able to point us to any case which speaks to contract A or the process contract, which had a clause similar to 2.6?
That they are entitled the blanket clause of termination?
Yes, yes, exactly. So you have said that there are cases which form the foundation for finding a process contract, so that the tenderer must act reasonably, must inform the bidders, etc., etc. And if that is breached, there's a remedy in damages, possibly wasted costs and so on. I'm asking you, in any of those cases, are you able to identify a clause like 2.6, which gives carte blanche right to terminate the process at any time?
Your Honor, in the two authorities that we have mentioned, Your Honor, but the case that we recently submitted to the court, which is the Borganza case, which deals with contracts and contractual rights of parties, and deal with fairness in the contractual rights, that even when you can't act arbitrarily, even when you do have the right to terminate the process. In the Borganza, it was treated that even if you do have the right, whether by inequality of bargaining power or whether you were the person that could unilaterally, excuse me, Your Honors, that could unilaterally terminate, and you had that power in the contract, you were still under a duty to act fairly.
Yeah. You, Mr. Dutherden, still on the same train of inquiry as the President has started. At some point you said, let's remove contract A from the equation. Now I'm asking you to bring back contract A into the equation. Is it the case that you're saying, well, there is a duty to act fairly, duty to consider the bids put in, and if you're going to cancel even in accordance with clause 2.6, you must inform those who have put in the bid. That's your argument, and that's a matter of fairness. Is that correct?
Yes, please.
And that argument, the respondents are saying that your condition, or rather your offer, was conditional. It was not a firm offer. And that conditional offer, as at the time of commencement of the litigation, had not been lifted. And the litigation basically overtook that process. If that is the case, do you even have a contract A?
Your Honor, there was a contract A for these reasons. What was being said, or what was being submitted, as I understand it, Your Honor, is that because it says that the bid was subject to due diligence on the assets, that it was conditional upon due diligence being completed. This RFP says expressly that investors would be permitted to conduct due diligence.
So why did you request an extension then in January?
Your Honor, but in the RFP, it says that you can do that.
That's the point. But when you request that, it means you have not put in a firm offer, have you? While that due diligence or that extension is still pending. So, in other words, the litigation
Brought in the court wanted and sought compliance with the RFP. So it was very straightforward, compliance with the RFP. So everything that was in the RFP could have been done. The reason the action was brought and the affidavits and the application is because what was said is Mr. Ram, the receiver, had departed from the RFP and was pursuing the sale of the shares of the company to a third party. That is why an order was sought to comply with the terms of the RFP. He still never did it. He said in his evidence 10 years later that he took no other action because he gave an undertaking to the court. But what undertaking did he give?
Mr. Dattadin, I'd like to come back to the due diligence point we were on.
Yes, please.
I appreciate that you've drawn our attention to Clause 11. But I just want to be clear that the nature of the bid submitted isn't, I read the nature of the bid that was submitted as inviting a different kind of due diligence. I just wanted you to clarify something for me. If we could please go to the actual bid that was submitted. I am personally on page 614 of the record of appeal. No, you rightfully pointed us to clause 11 of the request for proposals, which addresses due diligence. But I understood that provision on due diligence to be speaking to the due diligence that a selected investor has the discretion to carry out even after being selected. So you've been selected as the investor. You are the entity that the requestor identifies to be awarded the bid. And what I understood clause 11 to be stating is that even after you've been selected, you have the right to carry out due diligence, additional due diligence it's referred to. Is that what is being referred to in conditions of offer here? The reason I'm asking is if we scroll down, this seems to be pointing to due diligence that Cara Investments is saying it needs to carry out even before it can be considered for selection. So I just wanted you to clarify if I'm looking at this correctly. This is why I'm wondering if that's why the lower courts considered the bid that was submitted to be one that wasn't capable of immediate acceptance. Because when I'm reading the conditions of offer, it's actually saying, let me scroll down, as verification process. Then if Cara is selected as the designated investor after notification, terms of payment would then apply. I'm just trying to clarify.
Yes, please.
If what the offer or bid is saying is that, look, we've submitted a bid, but before you can even consider us for selection, there's some due diligence we need to carry out. That seems to me to be a little bit different than what clause 11 is speaking to. So if you could just confirm.
Your
Thanks.
Honor, respectfully, it is conditions you have to that offer. So Cara submitted an offer, and Cara said, what are the conditions to the offer? So the issue of it being, whether the offer was complete or could be actually awarded on the basis of that, respectfully, Your Honor, would not yet arise because Cara followed the format that RAM requested the receiver. He said, tell us your minimum price, tell us what your capacity is, and he said in heading 6, what are the conditions to your offer? If you had no conditions, you could say no conditions. If you have conditions, whatever you choose as your conditions had to be evaluated. And that means that the bid submitted was compliant. And Your Honor, we have one other aspect of it.
But why the request for extension then?
Your Honor?
The request for extension of time, what was that all about?
Your Honor, there was a request from December 29th to a date further in January, which I believe turned out to be the 12th, because they had indicated that they needed to have experts or they needed information, that it was in the middle of the Christmas season, and they asked if they could have more time. The receiver agreed and gave everyone more time. and they submitted a bid in compliance with what was asked. Now, if the bid document and if what is requested, the format of the bid provides expressly minimum, but it also says what are the conditions of your offer. That was a compliant bid.
Mr. Datadin, and let me see if I understand what you're trying to say, just so I can be clear on it. You are saying that you engaged a process and followed the process prescribed.
Yes, Your Honor.
Your complaint is that the receiver simply did not act in accordance with the principle of fairness.
Yes, Mr.
That's all. That is to say that even if the receiver wanted to terminate or cancel, that was fine. But the receiver ought to follow the principle of fairness, which in this case meant to communicate that to Cara as a legitimate bidder.
Yes, Your Honor.
That's your case. And is that case bolstered by the fact that you say the injunction of the court compelled by court order that process to be followed?
Yes, Your Honor.
But even without the court order, your argument remains the same. The court order simply gives the imprimatur of an order that Mr. Ram should have followed the process. It doesn't change what should have been done, i.e., that the principle of fairness should have applied.
Yes, please, Your Honor.
If there is no process contract A, does the logic still flow under the terms of the RFP and the duty of fairness under the Companies Act?
Your Honor, the duty of fairness, respectfully, it is my humble submission that the duty of fairness under the Companies Act would always apply. That is a statute, and every receiver is bound by that in everything they do, not only with bids, but with everything that they do.
No, we're talking about bids. Yes.
But involved in the bids, yes, that duty would apply.
So the process contract A, how does that advance the argument from your point of view?
Your Honor, because what would have happened at that stage? So there is the statutory
Duty.
right, but then now that you have requested by an RFP and you have received compliant bids, you need to act now because there is now a contract A or an.
So the only difference is the nature of the duty. The first duty falls under a statutory obligation. The second falls under a contract.
Yes, please, Your Honor.
Called contract A, implied because there has been an intention to create legal relations around the processing of the bid.
Yes,
That is a subsidiary contract.
Yes,
It is
Your
a contract to follow a process in relation to a bid, not to grant a bid.
Correct.
And that process, you say, includes the process of, possibility of termination or cancellation. You don't argue about that. But what you say is, if you're going to do that, then the due process in that contract would be to inform those who have submitted bids. You say
Yes.
you have submitted a bid, it is compliant, because even though a decision could not have been made about it, you were in the process as prescribed by the RPF. And you didn't go further because the receiver did not engage the process further.
Correct, Your Honor. And, Your Honor, we also rely, Your Honor, on the fact that the evidence of Mr. Ram is I did not do anything else because I gave an undertaking to the court.
I think we got you on that one. But just to follow on a little bit from the questions just asked. So the breach, as you understand it, you're arguing, is that you're not informed.
Yes, that would be the long and short.
Okay. So what damages are you claiming for that?
So,
14 million US dollars?
Your Honor, here's where, as it relates to damages, we didn't.
No. But before we get there, I'm just trying to be clear. In the dialogue you had with my brother just now, The only breach that was identified was lack of information, notification to you that your bid was unsuccessful or would not be considered. Now, am I right in saying that is the extent of the breach?
Your Honor, that would be, yes, in a nutshell,
Yes.
the
Yes,
RFP was not followed. What
and it was not followed because there was no notification to you
Yes,
that
please,
the
Your Honor.
process was being terminated. Okay. I understand that.
But you're not contesting that.
Yes, please, Your Honor. Yes, please, Your Honor.
What you're looking for is the measure of damages from a failure to send you a letter saying that you are not successful. We have just established that that is the extent of the breach.
Yes, please, Your Honor.
Right. So when we are correlating that to the quantum of damages, I want to see that straight line between what you're now going to propose to us as damages and the breach, which is lack of communication to you.
So, Your Honor, the damages is going to be governed or prescribed by the Spencer v. Harding line of authorities, which is the loss of an opportunity.
Mr. Dattadin, stop. What opportunity?
The opportunity.
Hold on. You have agreed that the receiver, just stay with us, please.
Yes,
leave
please, Your
the authorities for a little while. We can always find the authorities. Just
Yes.
stay with the argument. You have agreed that the receiver could have canceled this in compliance with the RFP 2.6.
Yes, Your Honor.
If the receiver had sent you a letter saying, pursuant to clause 2,
Your Honor, so the submission that we made.
no, I'm not interested in the submission that you made. We've
but-
read that, Mr. Dattadin.
No, but
Mr. Dattadin, please stay with me.
Yes, please, Your Honor.
Trust that we have read the papers.
Yes,
we know
please,
you
Your Honor.
want your 14 million. We've read it.
Your Honor,
All that you have lost is compensation for the failure to exercise a cancellation through a fair process. You have not lost an entitlement to be considered, 2.6 allows the receiver to say, I'm not going to consider you. You've accepted that.
Yes, please, Your Honor.
So all that your complaint reduces itself to is a procedural failure. You say either under the company's law, the principle of fairness, or under a subsidiary contract in which it is implied to have done what the procedure requires in fairness to a legitimate bidder and say, sorry, thank you, no. What is the measure of damages for that?
Well, Your Honor, I know the court doesn't want me to refer to that, but if I
Compliance with the RFP.
yes, please, Your Honor. So the receiver then circumvents that and engages, negotiates, as could be seen in the agreement of sale.
That may have been a breach of something under company's law, no problem. The junction never dealt with that. The junction simply
No,
said,
please, Your Honor.
follow
But
the RFP.
Again, so the receiver, having done that, went around it and disposed of the assets, and he did the agreement of sale. It's mentioned in the agreement of sale that he was negotiated and he was paid, and he's a signatory to the agreement of sale.
Mr. Dattadin, I
Cara?
have to come back to this because we will return very, very quickly to this question of damages, but you keep saying that the receiver manager acted outside the scope of his powers. And I'm just curious as to why you keep saying that in the circumstances of the powers awarded to the receiver manager under the debentures?
Your Honor, because shares are not assets of a company. The shares belong to the shareholders. He has the debenture is to act over the assets of the company. So the cars, all of the fittings, the hotel, the everything, those are the assets. But at every stage, the assets of the company.
You received from Mr. Justice Singh following clause H of the writ of summons might have been a blank shot.
Well, Your Honor,
If it is the
whether-
case, if it is the case that the receiver has no authority over shares, but only assets, but then we have an injunction that is binding on the receiver, binding on him to not do what? Something he doesn't have a right to do, which is deal with the shares of the company? Does it mean we had a blank shot?
Your Honor, you mean he circumvented the order of court to do something else?
No. In the sense that the injunction didn't really bind him in relation to the shares because he had no authority over the shares. It is the shareholder to sell their shares or agree to dispose of the shares.
Your Honor, if I could respectfully say, I don't think the injunction was directed to anything except the RFP. So whatever the RFP said he could do, whether it was shares,
Yes.
whatever he could do.
And the RFP was about assets, not shares.
Correct.
Okay. So,
The point is, this case,
fired you with quite a bit of questions, and you've done quite well in parrying them. At some point, again, let me put it this way. Is it fair to say that the contours of this case when it started
Yes, Your Honor.
might have been mapped out in paragraphs 13 and 17, paragraph 13 and 17 of the affidavit of Ms. Davina Stevenson in the interlocutory motion?
I can't grasp, but that is essentially yes.
Essentially, yes. If we looked at, for instance, the appeal record, page 81,
Yes, please, Your Honor.
appeal record, page 81. Yes. Paragraph 13 there says, a catalogue of the deferrals and the utter dismay of the plaintiffs were communicated to the defendant on December the 15th, 1999. Apart from being unbusinesslike and non-commercial, this affected content has not considered, alternatively has not fully considered their proposal, and that it is intent on making a statement shortly that may perpetuate himself in his current office to his financial advantage, or make an allocation to someone, included himself or another party, whose proposals were made outside the closing date or after closure of other bids, and which the defendant has some special interest, unquote. Would that be the gravamen of your litigation when you started it?
Well, Your Honor, as we've put in our submissions, there is much complaint about the subterfuge, if you like, of the receiver. But respectfully, Your Honor, that's not where we think the case really lies. The case really
No,
lies.
I'm asking what was the concern when you commenced the litigation in the context of which this affidavit was filed?
The concern, as I understood it, Your Honor, I was not at the very beginning, but my understanding and my instructions are that what was the concern is that the RFP was not being followed. And what was the opening of the bids is where it started going in a different direction, and the bids were not opened. They thought they would be able to be present. So that's what started it. So the order was, go follow the RFP.
Okay, let me finish this inquiry and then I'll round it up here. Now, we've seen here in the deposition or attestation of Ms. Davina Stevenson, the company secretary, I understand it. She has mapped out what was troubling the company. Is it correct that in his own affidavit, Mr. Paul Stevenson, the co-chairman,
Yes.
spoke to this matter of conflict of interest? And he said that the directors of the hotel, and he specifically mentioned Mr. John or Johnny Carpenter, would speak to this allegation of self-dealing. Is that correct?
Yes.
All right. And Mr. Mr. Carpenter testified.
Yes.
Did he speak to it in his testimony?
He said they received the proposal.
No. Did he testify to self-dealing and conflict of interest?
Your Honor,
If I
in my
recall-
humble submission,
Did you take him in his examination in chief?
yes, Your Honor.
Is it
And
correct to say that his examination in chief was very, very brief?
It was
Something like, according to the note of the leave,
just a little portion.
something like 17 lines,
That's correct, Your Honor.
and he never testified to self-interest or self-dealing.
What he did say is that Ram was involved, the receiver was involved in the
No,
sale
no,
of
but
the
he did-
shares, in bringing the proposals.
But you did not lead him in his examination in chief in that direction.
Because respectfully, Your Honor, as we have indicated, there may be all of those issues about the subterfuge that we would want to say. Respectfully, the issue is, was the RFP followed? Wasn't it followed?
Fair
Was
enough.
there a
Thank you.
contract? And wasn't there? And evidence of that would really not have advanced us or taken us any further along the road we hope to travel.
Okay, my brother, that's good. Yeah, thank you very much, Mr. Dattinen. I must say that there was one point that you were getting towards, and some of us on the bench diverted you. I think Justice Jamadar was very guilty, and so was I. You wanted to talk about damages. So you want to say a few words about that before you...
Your Honor, the damages for a breach of a contract would be, if there's a concluded contract, the first part would be to put you in the position as if the contract would have gone on. This contract was not at the stage where the value of the asset itself is, because we're only complaining about the evaluation, the duty to act fairly part. So it does not end or it does not arise to the full extent of the value. I know the court has indicated about the submission, so it is the loss of the opportunity of going forward. The courts, in assessing the loss of the opportunity, evaluates and the cost of getting people to present and get all of the work that is required with the valuation. And of course, what was done is that they had demonstrated that they had to some extent secured the financing that would be required. But, Your Honor, that is not to say that a contract was entered into for the sale of the asset. There is no evidence, and despite a trial, there was no evidence produced as to how many other persons were affected and to how many other issues would have arisen. So
Is there any evidence of your wasted costs? Suppose we agree with you,
Yes, please, Your Honor.
and there was this shortcoming. Is there any evidence of, so you invested stuff, you paid your 100 US.
Yeah.
I suppose you want that back because you say, you unlawfully terminated the process. What about wasted costs? Is there any evidence that, look, it cost us 500 US, 5,000 US, 14 million US, I don't know, to prepare this bid? Is there any evidence about that? The cost, the costs that you incurred, that you say costs are wasted because the process became fraud?
Your Honor, in Mr. Stevenson's evidence, what Mr. Stevenson's outlined is what was done by but it doesn't have a dollar.
So if you are ever entitled to that, you agree with that?
I agree that I would go back through, and in my reply, if I can be of assistance in that specific regard, I will do my very best to be of use.
The only evidence we have is you paid $100 US.
Yes, please.
For the
Your
bid.
Honor.
So based on that, give us a dollar figure, what you think you're entitled to?
Your Honor, the loss of the opportunity is the loss to be able to own an asset, another hotel which a hotelier is bidding for. Given that there would have been other persons involved, and given the manner in which it would have gone on, Your Honor.
And inflation, of course.
Yes, Guyana is an interesting place. Now, Your Honor,
you need to say something to us.
So I would, Your Honor, I would take it this way. And last night, I was trying to figure out if we ever got here what to do. And I would have said, Your Honor, this would be the thing. If the value of the hotel, if we take the value of the hotel to be approximately $2.5 million, and 10% of that amount were awarded as costs, because we take the balance of how much was...
That is a method unknown to me.
I know, Your Honor.
That seems to be a data-in method.
No, please,
for the
Your Honor.
computation of loss of opportunity. Take 10% of the cost of the asset, and that's the loss of opportunity.
There was one other issue I wanted to just cover, Your Honor, and that was the issue, because it has arisen, or it is arising in other matters in the pipe. And, Your Honor, the decision of Justice Moore, when he said a motion was filed to strike out the statement of claim, and he made a finding of jurisdiction, essentially, to say that there was a contract. And as a result of that contract, the action would continue. There was no appeal to that. But, Your Honor, it would be of some value if we could have, I don't want to say what the court should write about or not write about, Your Honor, but given the way litigation has been going, there are matters, and there is some guidance about whether it is a matter germane to the trial itself, or whether it is a matter that is ancillary and separate to the trial. In these proceedings, Your Honor, it was a motion that was filed to strike out the action, and the court determined there was a contract to which there was no challenge. So
Mr.
respectfully,
Dattadin,
Your Honor.
Having raised that, why did you cite this court's judgment in Garraway as authority for the point that the matter would now be res judicata?
Well, Your Honor, because Garraway was one of the legendary Guyanese cases. Your Honor, it went through the entire court system, and I think there was a comment made that if it was prescription, we would have had a different view. And a judge made that comment. What happened is they lost in the Court of Appeal. Armed with this comment, 3 months later, lo and behold, the same attorney filed through the process of prescription. What the court said is res judicata applies because it is not only what you raised or what you didn't have, but what you ought to have raised in the dispute. those issues would bind you. But the issue was issue estoppel. And in this particular case that we have, the determination as to the existence of a contract was made by Moore J. He said this was a contract.
Just really briefly, Mr. Dattadin, the reason I asked you is I thought the court had very clearly stated that one of the essential conditions for res judicata is that you have to have a final decision on the merits of the issue. That was said very, very clearly. Do you consider a determination made by Justice Moore that the pleadings, the facts as pleaded, which clearly had not been proven at that stage, disclosed a contract to be a final decision on the merits of the issue? I'm just leaving that with you for consideration.
Respectfully, Your Honor, yes. And the reason was the motion asked to strike out, put in paragraphs in the affidavit, put in submissions that there was no contract. The basis of the matter being should be struck out is that there was in existence no contract.
Your argument was that there was
The argument was
no cause of action known to the laws of Guyana. That's the full context of that.
I'm sorry, Your Honor.
The motion to strike was that motion to strike on grounds that there was no cause of action known
Yes.
to the laws of Guyana. That's the context. No cause of action known to the laws of Guyana.
But in the submissions and in the affidavit, what they said is there was no concluded contract. And Justice Moore decided that there was, and they didn't appeal it. So it was the thing that gave the court jurisdiction, and therefore it's a final binding order, because it doesn't have to come to this court to be parties stop at the first tier, then it's done. And in this case, they did not pursue it, and 10 years later at the trial, we raised it to the trial judge. That trial judge would have had no authority to revisit what another judge had done.
Okay, I think we could probably hear from the other side on this point. I think we will. So shall we put that off until then?
Yes, Your Honor, and I will be back with an answer.
Yes, I'm sure you will. Thank you
Yes,
very
please,
much, Mr. Dattadin. Okay, so I think we have Thank you, everyone. I think we are now ready to resume these proceedings with submissions from the attorneys for the first respondent. And I gather Mr. Boston, Senior Counsel. And you have an impromptu junior, you said. Okay.
Your Honors, the preliminaries that Mr. Dartidin submitted about the request for proposal, I will adopt those preliminaries. That is a fact. Cara sent in a request for proposal, as well as other persons sent in a request for proposal. But I will go with the request for proposal and first deal with the instructions that the request for proposal gave to the invitees who may wish to submit a proposal for the purchase of the hotel. What is interesting, paragraph 1.3, the purpose of the request for proposal is issued to invite some formal proposal from investors to bid for the assets of Hotel Tower Limited pursuant to 3 debentures for which security is pledged at the Bank of Nova Scotia. Another important clause is the cancellation clause. The receiver manager is not bound to accept any of the proposals submitted and reserve the right to reject the proposal in whole or in part, and to discuss different or additional aspects which any investor to terminate the process described in the RFP and in the preliminary information packages. Then we have paragraph 8, notice of description as investors. Paragraph 8 speaks about notice of designation as the selected investor will be delivered by the receiver manager to the investors submitting the most attractive and practical proposal. So the investor who was submitted the most attractive proposal, that person will be identified as the selected investor. At paragraph 11, paragraph 11 deals with due diligence. It says the selected investor will be afforded the opportunity to undertake due diligence to confirm the assessment of Hotel Tower Limitation operations, including its subsidiary Emerald Tower Limited, made in the proposal. In anticipation of the process, investors submitting proposal should indicate the additional information that they believe is required and the time frame for conducting and completing the due diligence process. As investors will have the opportunity to conduct due diligence regarding Hotel Tower in the course of preparing the proposal, it is envisaged at the time required for a selected investor to conduct additional. This due diligence has never put this instruction to invitees, has never says that a condition precedent for you to put in your proposal, you can submit a conditional offer. You first will have to be identified as a selected investor. And because every participant or every invitee who has submitted a proposal are prospective selected investors. So it is not until when you are identified as a selected investor, then you are requested to set out what information you want and how long your due diligence process will take. So when Cara has submitted its request for proposal, Cara request for proposal was tabulated in chapters, and chapter 5 deals with due diligence, and chapter 6 deals with documents under the heading of condition of offer. So Cara was asking there, at that point in time, without being identified as the selected investor, that what Cara needs is time to get things, to do the due diligence, and at the same time, to get additional information. So what Cara really did was submitted a conditional offer. So based on that, the law surrounding the tender process, we are submitting that outside of 2.6, Cara has never made a case out during the trial before Justice Ian Chang. Never did. The authorities are quite clear on those issues. They're saying that a response to a tender call can give rise to a process contract. In New Zealand and Australia, they speak about a process contract, and in Canada, contract A.
Counsel, could I just take you back to something you just said? You said outside of clause 2.6, Cara Investments has not made out a case.
A case.
Could you just clarify what you mean by outside of, are you saying that they have a case with respect to clause 2.6?
No, in relation to 2.6, that kills Cara if when the receiver decides he can just withdraw the process without complaining without telling anybody anything. And at the same time, outside of that, the evidence that was led by Cara is also revealed that Cara had no leg to stand on.
Okay, Counsel, as you develop your points relating to a process contract, could you respond to the submission made by Cara Investments that there was a breach of a duty to communicate cancellation of the tender process? Thank you.
Now, it is respectfully submitted that there was no breach to communicate the cancellation of the contract to Cara or any of the invitees who submitted proposal. When the law is to determine whether the process contracts comes into being, one has to look at the terms of the tender call, the terms of the tender document, and one will look at it and say whether there was any intention to create contractual relations by virtue of that tender call. Mr. Cara was arguing, since they have paid the $18,000, they have sent the confidential letter, and they have access to the information room and they photocopy documents. That by itself indicates that Christopher Ram intended to create contractual relations. Assuming for this purpose that that was so, but the authorities made it quite clear what that document would have been doing. It was an offer to the invitees that if you submit a compliant bid, then the tender, the person who gave the tender call will be duty bound to open your bid and consider your bid in the process of evaluating the other bids. And it is said that you have to deal fairly and equally with all the invitees who have submitted bids. There must be an acceptance of that offer that was made to the invitees that if you submit a compliant bid, I have the duty to consider your bid and deal with it fairly with the other invitees who had made that proposal. But what Cara did, Cara submitted a conditional bid.
So, Mr. Boston, let me ask you something. If Cara had not submitted a conditional bid, because my understanding is your argument about the conditional bid means they don't even cross the threshold, because it was a conditional bid.
Yes,
so there was no duty to even consider it at all.
No,
or
because
respond.
it's non-compliant.
The RFP didn't even kick in at all. Because,
No, sir.
So I understand that. If their bid was not a conditional bid, is it that your position is under this RFP that would have created a process A or contractual obligations to treat fairly, et cetera, et cetera?
I don't think so.
So in the alternative, even if they had submitted a compliant bid, you say, nevertheless, they would not have been duty-bound, Mr. Ram, to open and consider and to treat fairly and equally.
Invite some formal proposal from investors to bid for the assets of Hotel Tower Limited pursuant to the treaty. So you are inviting them to bid for the assets. So, and this is how the Chief Justice looked at it. He said it was an invitation to treat. It was an offer to invitees that if you submit a proper offer, then Christopher Ram can accept that offer. But if you are submitting an offer, a conditional offer, it can't be accepted.
No, I'm on if it was a proper offer. I'm understanding you to be saying that because it was a conditional offer, it just didn't get off the ground. I understand that. If it was a compliant bid, if the bid complied with the RFP procedure, would a process, a contract have come into being in relation to how it should have been treated?
Of course, if the terms of the request for proposal
it fairly. Yes, is that it fairly? Yes, is that what you're saying?
well, fairly in the limited sense to consider.
Yes, understood.
And sense to consider.
Yes, understood.
And deal with it fairly.
Bids and consideration of the bids?
It allow for the receiver to vacate the process, even though a compliant bid was submitted before a contract was executed. And if executed contract means they would have all had to sign that contract. If executed in that sense means a contract that were signed by the parties.
Is there any limitation in terms of the time or the stage at which there could be this cancellation? Because the clear wording suggests that the receiver manager is not bound by any proposal submitted, reserves the right to reject proposals in whole and in part and discuss different or additional aspects with any investor to terminate the process described in this RFP at any time before definitive agreements are executed. So is there any limitation as to when this process could be terminated by the receiver
There
manager?
is, Your Honor, there is no limitation.
Okay.
He can wake up and buy a side wind and I'm not going through.
And would that then be a breach of any duty to act reasonably or fairly?
If that will be a duty to act
Would
reasonably,
that be a breach?
submit a proposal, understands that the proposal I am submitting, this receiver, pursuant to clause 2.6, without a contract being executed, can just recall the process.
So a conceptual framework within which to view this is, of course, the contractual framework.
Yes, sir.
And what I'm trying to tease out from you is whether you think that clause 2.6 is relevant to identifying the existence of a contract. So is it that there's a contract A?
Contract, if you can just, before a contract, no, sir. It reflects that there is a contract, because if before a contract is executed, you can just avoid it, then it contemplates if a contract is in existence, then you can act in a particular way.
Okay, I'm not sure I follow you 100% there.
In which clause 2.6 still part of it? Or are you saying that somehow 2.6 can prevent the creation of contract A?
Your Honor, I think clause 2.6 one can contend that it can be incorporated into contract A, the process contract, because you have to look at the terms of the.
I'm not saying it's not. I'm just asking you the same question I asked of Mr. Dattadin. Are you aware of any process contract which contained such a clause? 2.6?
No, sir. I have read a lot of Canadian cases. I don't know of any such.
Okay. And put another way, if 2.6 was worded differently, could it have the effect of preventing a process contract from coming into being? If 2.6 says a process contract from coming into being, if 2.6 says there is no intention to create a contract between the person giving the bid and the one receiving it, would that be sufficient to prevent the existence of a contract A or a process contract?
No, sir. I don't think so. I don't think so.
So you don't think that one party can prevent a contract from coming into existence?
Of course, one party can prevent a contract from coming to existence if that party had no intention to create legal relations, contractual relations,
Okay.
because it takes the mind of two persons.
Ad item. Thank you, sir.
Mr. Boston, sorry to burden you, but I just want to be very clear. Your position, as I understand it, is that the existence of clause 2.6 is part of why we say there was an intention to create this process contract. But in that process contract was 2.6, which gave the receiver the power and capacity to terminate or cancel, as you say, if they get up in the morning and decide to do it. It's as broad as that. Is that what you understand?
Yes, that's what I'm saying. It is
Yes, no,
incorporated.
fair enough. So would there be a added duty if you got up in the morning and decided to cancel it, to communicate that? So that we progress where we have a process contract, 2.6 is part of it, you could terminate it on a whim, right? You decide to terminate it on a whim. Is there, in this fairness that has come in now, is there a duty to communicate that to the bidders?
I think that depends on the receiver. But even that were the fact, Your Honor.
No, I'm asking you a question of law. This is not a question of fact, a question of law.
Yes, a question of law, I don't agree.
You don't, right.
I don't agree.
No, you can terminate at whim, no duty to communicate.
No duty to communicate.
Okay, thank you.
As the court was interrogating counsel for the appellant this morning, the counsel for the appellant says that there was a breach of the RFP, and the breach of the RFP is failing to communicate to him that his bid was probably not considered or the process was terminated. But when one looks, the appellant filed his request for proposal on the 12th of January. Of course, you will have to give the receiver the opportunity to consider what you have filed and to evaluate it with the other invitees. But there were 4 other invitees who had contributed proposals. And one of them was 4.8 million US, one of them was 3.5 million US, one was 2.8 million US, one was 1.5 million US, and the appellant was 2 million US. After the appellant directors became privy to that information, what happens? The proceedings, the endorsement of claim was filed some 13 days later. The whole idea of that endorsement of claim was to frustrate the process. It couldn't be anything else. You were down, there were 3 bids above your bid. And at that point in time, the company indebtedness to the Bank of Nova Scotia was 2.5 plus million US dollars. So they realized they were flogging a dead horse because the receiver has a duty to obtain the best price available on the market at the time when he was going to enter into an agreement, a sale of the assets.
Just a small technical point. How did they become aware of the other bids? Was that through the documentation room?
No, sir. No, that was sent to, after the request for proposal was sent to Mr. Ram, he sent them to Nova Scotia,
BNS, right?
so Nova Scotia can decide, advise him as to the process forward.
Yeah, well, you're asserting that Cara got wind of these other offers, and that is why they went to court.
Yes,
How did they get wind of that?
the receiver did communicate to them.
Is that considered? Is that a no?
You mean told them before the High Court action what the three bids were?
Yes, they knew before the High Court action what were the other offers.
And the receiver told Cara that?
Yes, Cara knew that.
No, but
the
the president is asking you, how did Cara
The
know
receiver told Mr. Carpenter and the director there. They knew of it.
Give evidence from there, but just to, Mr. Datton, is that a conceded point or not?
Or whether there's evidence of it on the record.
Is there evidence? Mr. Boston, is there evidence of that on our record? Perhaps we could locate it whilst you're continuing your submissions. We could come back to that, please. Yes.
But Mr. Boston, I'm a little, let's assume all that happened and they get the injunction. But wasn't the injunction to saying to the receiver, follow the process of the RFP? Cara, on your factual matrix, Cara is aware that they have of three bids, they have the lowest bid, correct? So they go to court and they get an order saying, you need, Mr. Receiver, to follow the process of the RFP. Couldn't the receiver have just followed the process and allocated the bid to the person who you say had the highest bid, or canceled the bids, or terminated the bids, or terminated only Cara to say, because, look, you're too low, we're not even interested with you? I don't understand why you say the injunction stopped the RFP process. I thought the injunction was saying you must continue the RFP process.
But the only RFP that was complained about, Your Honors, is the fact that no notification was given to Cara about what took place, about the bid. That is the only complaint. They were not informed about the state of their bid.
Counsel, you made some submissions earlier that suggested that in particular circumstances, a contract process could have arisen. I wanted to just take you to your written submissions, please, around paragraph 47 to 54. And I just have a very specific question about those submissions. Want to be clear, are you acknowledging to the court that it is possible for a process contract to arise in the context of a private tender process? I'm asking because the way those submissions read, it suggests that there may have been a problem in principle with a process contract arising in the context of a private commercial tender process. So I'm just giving you the opportunity to clarify your position on that point, please. Is there an objection in principle to a process contract arising or a contract involving an undertaking to act fairly arising in the context of a private tender process? Thank you.
Yes, a contract, a term can be implied in a private contract that the person who gives the tender call has a duty to treat each invitee fairly and equally. Because in the commercial world, if a businessman wants to bid for a property, he has to go through processes It depends. He has to get a valuator who will value. He has to put out money in order to get himself in a state of readiness and competitiveness to win that bid. And if he knows that by a side win, the receiver or the person who is calling the tender shot will disregard all the bids and identify a particular bid, that will discourage, that wouldn't be a fair process.
To put a pin on that then from my sister's question, you are residing from your submissions, paragraphs 47 through 54.
Yes, I'm certainly saying that a private contract, the approach should be the same as a public contract.
That's what you're saying now. Okay.
Yes.
All right. We follow. Yeah.
The same question was raised by Lord Tolson as well as Lord Bingham in Blackpool case, and they haven't decided it. They say at some future time they will decide whether the approach in a private tender is different from a public tender for public works.
But you're submitting that there should be no difference.
Having reviewed it, there should be no difference in the business world.
So despite what they may say in the United Kingdom, we in the Caribbean, in your estimation, should follow the path that you have suggested to
Well,
us.
yeah, I will think that the common law grows by a series of an analogical extension, and this court can say, this is what it is.
You think, let me ask you that, you think that would be good in our Caribbean spaces? That would be good for the development of the law in our Caribbean spaces? You're a Caribbean person as we are.
Yes, I think so.
Yeah, okay, good, thank you.
He's asking you a question. Huh? He's not
So this court will say whether the private approach should take the same form as approach by bidding for public works or public property.
Yes, I think we follow you on that. Could we go back for a minute to the injunction that was granted against you? And it seems to me that one of the things we have not sort of dissected enough is whether there was in fact a breach of this injunction by what happened subsequently. So the injunction restrained from awarding or allocating the purchase of the Hotel Tower Limited until you had complied with the RFP and so on. Did you comply with this injunction?
From parting with possession by way of sale
Yes.
of the assets?
Yes.
The first name respondent did not part with the assets of the company by way of sale.
Right.
It was the shareholders who decided that they will sell the shares in their company to somebody else.
Yes, I thought so. I just wanted to be clear on that. So that is what Mr. Dattin refers to as you're circumventing the injunction, but you're saying you're acting completely consistent with the injunction.
Yes, Your Honor.
Okay.
And the injunction didn't put any restraint on Mr. Ram from seeking the advice or being a part of what the shareholder wants.
Yeah, okay.
Mr. Boston, I'd like you to help me understand how clause 2.6, some call it privilege clause, some call it escape clause, cancellation clause. How does that play with clause 8.0 that you referred to in the course of your submission? Here is my question. Clause 8.0 says, notice of designation as a selected investor will be delivered by the receiver to the investor submitting the most attractive and practical proposal. Does that suggest that by that provision, the party issuing the call, the proposal, is bound to select somebody who made the most practical,
Yes.
attractive offer? If that is the case, how does that relate to clause 2.6, which says that the receiver manager is not bound to accept any of the proposals submitted and reserves the right to reject proposals in whole or in part, etc., etc. How do the two provisions interplay?
I don't, with the greatest respect, Your Honor, I don't think it is in conflict. You can only identify a selected investor after the requests for proposal have been evaluated. It is not until that is done, then a selected investor will be identified. And that selected investor will be notified that he is the selected investor. And having so notified, he now will have to ask for certain information, and he will have to say how much time you want to do due diligence so the process can move forward. In the absence of a selected investor, it tells you that there was no evaluation, and no evaluation could have taken place because of the injunction. Because if you evaluate and you identify a selected investor, you can't move forward to sell the property to that selected investor unless you use the 2.6, which is my view is incorporated if there was a contract A, and you can get out of that.
Mr. Boston, could you just repeat something you said? Did you say that if an investor had been selected because of the injunction, the receiver could not have moved to sale of the property?
Well, the injunction speaks for itself. You cannot part with the assets of the company until the hearing and determination.
Okay.
So if he is selected as the investor, the next thing he will want to move forward and pay his 4.5 million or his 3.5 million and get the assets of the company.
Right. So going back to a question that the president had asked earlier about the interpretation of the injunction, which is now on the screen. You interpret the injunction as not only requiring compliance, requiring the receiver manager's compliance with the RFP. You interpret the injunction as preventing the receiver manager from disposing of the assets
By way of sale.
until the matter is determined.
Yes.
So you're saying even if the receiver had been acting in compliance with the RFP, you read the injunction as restraining the investor from actually disposing of the assets?
Yes, Your Honor.
until the determination of
Yes,
the
Your
hearing? Okay.
Okay. Are there further points you want to urge on us?
Yes, just two other areas, Your Honor. In relation to the appellant's second ground, where he has said that Justice Moore's order was a final order, and there was Justice Chang couldn't rule against that. Justice Moore was ruling on a motion to dismiss the statement of claim because he said it discloses no cause of action. And it was the duty of Justice Moore to look at the statement of claim and based on the pleading, whether that statement of claim discloses a cause of action. But he was not there to determine the final rights of the party. The final rights of the party were to be determined by the trial judge, who will hear the evidence and then come to a conclusion based on who he believed. So what my learned friend is saying, no, Moore said this, and I am bound by, Justice Chang is bound by that. But Justice Moore was not interrogating the rights of parties. He was dealing with an application to strike out. And this is my view. I looked at it, and as far as I'm concerned, then declare a cause of action. And when the rights of the parties are to be determined, then the Chief Justice will have to decide that. And that is what he did. And in relation to the question of damages, my learned friend says he's claiming the measure of damage as a loss of profit from loss of a chance, but this is all misconceived. What chance has he lost? What chance has he lost? Putting his argument at the highest, assuming that there was a contractee. And that contractee has to be evaluated among the other invitees. How is it he had 2 million US below the indebtedness of the company? What chance he has lost? He has to show that there was a real possibility that he would have acquired contract B. But you can't come. This is like going to a gunfight with a knife. You coming in with 2 million. The company has debts 2.5 million plus. And here your chance of defeating the man with the gun with your knife is really, really possible. You can't. So he has not led any evidence to show that there was an opportunity that he would have won contract B if he was arguing on the two-stage process, contract A and contract B.
Mr. Boston, on that point, perhaps the question I'm going to ask you maybe more for Mr. Daraden when he gets up to reply. But in the meantime, your views may help. The reason the whole thing started was because the hotel was in dire straits. He was losing money and had been doing so for a minimum of 8 years. That's all the point of the receivership. Yes. Some may say that that is a factor that makes the whole claim speculative because you will require a Midas touch for anybody to say, well, I'll come in and then company will start making instant profit, so which I would have lost. Now, but in the meantime, has that company started making profit since as we speak? And when did it start?
Well, it appears as though they were not making profit for many years because the value of the assets of Hotel Tower was less than its liabilities. So if it were to go for that great sum of $2 million, shareholders would have all lost. There was nothing for them. There was still more money had to be paid to Bank of Nova Scotia.
But beyond that, I hear you. I hear your argument in relation to that. But I'm trying to find out now the fate of the company to the extent you're able to advise. Has it turned around? Are things now looking up for the company?
Well,
Is it doing good business?
The company has passed hands to about 2 or 3 different persons. And it is said that the 2 of the persons to whom the company have passed hands to are very wealthy people.
Maybe you should not
one
say
second.
too much in open court.
Mr. Let me return to
Mr.
a general
Austin.
question, a general proposition. In your argument, you did say that assuming there is a contract A, you have given us your views as a senior lawyer in the jurisdiction as to whether or not there should be a distinction between public and private. You say there should not be any. But what about on the subject of contract A, contract B? Beyond the facts of this case, regardless of what the outcome would be, what would be your position? As you know, in Canada, they've been very clear in saying there is such a thing as contract A and contract B. In the antipodes, they call it process contract. In your view, should there be such a thing in a bidding process as contract A and contract B, as a general proposition?
Yes, sir. I think so, having regard to the contents of the tender call. And it might be a very complex tender call. There's so many things the invitees will have to do and the kind of money they will have to go spend. Obviously, one can come to the conclusion based on the contents that there was an intention on the part of the person who is giving the tender call to create legal relations.
Thank you.
It says quite clearly at paragraph 17, if what Justice ST is saying, that every tender call and every response to the tender call will give rise to a process contract, he doesn't believe that. He's not going to follow that, and that has been the trend from the Canadian authorities coming right down.
If there-
New Zealand also.
Yes. If there is no process contract, is there a duty still to act fairly, reasonably?
If there is no process contract, if there is a duty to act fairly, I must confess that there is a case I cited, a New Zealand case, where they said there is a duty still.
And
act fairly.
what's the source of that duty if it's not contract?
I do not know. I do not know, but that is the case I cited. That is.
Could it be public policy?
It would probably appear.
As you look for it, what is the scope of that obligation to act fairly? What would that scope be?
Well, I think that scope to act fairly in that regard will be to consider his document, even though he hasn't reached the threshold. But it is, Your Honor, I put Gregory and Rang, the Tiki District Council. I have it there, and you will see this judge from the Supreme Court. They are all been developing and perfecting this thing all along the line. And I will only be too happy if this is the apex court can perfect this, take a position, so we all learn and go along and say, this is what our court says.
We follow you very much. Anything else?
You mean that literally, President, or you mean you follow the submissions?
We understand you perfectly. I was hoping that I would hear from Mr. Ramkaran, and I wouldn't want you to cover all the ground so that there's nothing for him to cover. Is that the intention, that we'll also hear from you, Mr. Ramkaran?
Yes, please, Your Honor.
Okay. So is there anything else, Mr.
No,
Hassan?
Mr. Ramkaran and I are sailing in the same boat. So when I'm tired of managing the boat, he will step in and take over.
Are you sailing or you're rowing?
We are sailing.
Okay, I love your metaphors. Thank you so much.
Thank you.
Thank you. I think equal time, Mr. Ramkaran, would suggest that you could go until 1:30. If you can be generous with us, please
I
do.
think Your Honours gave me an hour. It's 1 o'clock now. 1:01.
Yes, I was looking at the equal division of time between both sides. But please, go forward. Let's see how far we get.
May it please Your Honours, from the time of submissions to arguments, this case has bolted out of the stable like a horse, and it is no longer the same as we came into it. No doubt because of Your Honours' piercing questions. We are now in different ground. I'd like to take Your Honours back to where we should be in my submission. This case is an appeal from the Court of Appeal of Guyana, which upheld the decision of the High Court, Justice Chang, and it was based on a case framed by the appellant, Cara, who put forward their propositions in their pleadings and in their evidence that they chose to put. They chose what remedies to seek from the court. They chose what evidence to place before the court. A decision was given on the basis of what was before the court. It was then appealed. The Court of Appeal determined on well-known principles relating to findings of facts as to whether there was any error in the decision of the High Court judge, and it has now come here to Your Honours on the basis of grounds of appeal. Today is the first time, Your Honour, that we are hearing about a breach of a contract based on a failure to give notice to the appellants that the process was going to come to an end. It's the first time we've heard about it. It has not appeared in any pleadings. It has not appeared in any evidence. There was no amendment of the case to bring.
Not the cricketers I know from Guyana, no. They're very adept.
But counsel, did they not complain that up until now they have not known of the fate of their pet? Isn't that their central concern? Is that, if that is their central concern, is it beyond contemplation that that concern may drag in arguments of lack of fairness because they've not received, they don't know where they stand?
They said so in their evidence, Your Honor, but I don't know if the first time they knew about the agreement in 2003, May 2003, where the shareholders decided to sell their shares. The directors, if you look at Clause 5 of the agreement of May, I think it's the 19th of May 2003. My friend will bring it up on the screen. Clause 5 of that agreement says that the directors have advised the shareholders to accept this proposal for the sale of the shares. So to say now, there was no amendment of the case when this issue came out in evidence. There was no contempt proceedings contemplated or brought. No one said to the judge, listen, this is something new. We haven't heard about this. We don't know about this. We want this to be a fundamental part of our case because circumstances are different. We can't come 13, 14 years later in the final court after two decisions of two courts to say, oh, we have now realized that these shareholders sold their shares and they didn't tell us that they were selling the shares and we want some damages based on what they did in 2003.
And you're arguing that they did not amend Clause H of the writ of summons.
That is correct, sir. And Clause H
where is entirely silent about disposal of shares.
certainly, sir.
Also, the argument, the injunction of Justice Singh also saying nothing about that. That's your argument.
So, yes, sir. There was an injunction which spoke about the assets of Hotel Tower. It spoke about the request for proposals. There was nothing to do with shares.
No, the injunction doesn't speak about assets. It talks about sale, award or allocation, purchase of the hotel.
Yes, sir. The purchase. But what had been happening in the request for proposals concerned the sale of the assets of Hotel Tower. There was never any question about the shares of Hotel Tower. If Your Honors will just give me one moment to bring the record up on my device so that I can see it. But the injunction granted by Justice Jainarain Singh, Your Honor, in 2001
Can you help us with the page number for that? Yes, you happen to have it?
It did not, while I get it up, Your Honors, I will tell Your Honors that it had nothing to do with shares. And so,
You're looking at, that's 634, isn't it? The appeal record, 634.
very good, Your Honors. So it says that the defendant, Mr. Ram, is by himself, his servants or agents are restrained from awarding or allocating the purchase of Hotel Tower Limited until the defendant complies with the conditions of the request for proposals dated November 1999. Well, the request for proposals, the conditions of the request for proposals dealt with the assets of Hotel Tower. So when this came up at trial in 2010, the trial took from 2010 to 2012 to be completed. When this came up in 2010, someone should have said, well, what is going on here? You sold the shares. We need to amend our case to do something. You might have breached an injunction. We need to bring this before the judge of first instance to determine whether this is so or not. But having not done so, Your Honors, I don't see how you can bring it up so many years later in the final court of appeal and ask that it be considered.
But Mr. Rangan, maybe I misunderstood the thing completely. I thought that, I don't know that I've heard that there's a question before us orally about the sale, about the transfer of shares.
Yes.
Whatever assets went with the transfer of shares, that's a different issue. What I thought I heard was that there was a compliant bid. That compliant bid, both under the Companies Act and under a creation of a process contract or a contract A, created a duty to act fairly. That duty is confirmed or given the imprimatur of the court by the injunction to comply with the RFP. And in compliance with the RFP, 2.6 is part of compliance, but the complaint is simply not in terms of transfer of shares, but that there was not a satisfaction of the duty to act fairly because there has been no communication about termination, cancellation, or abandonment of the bidding process. Your senior, Mr. Boston, challenges it on one fundamental ground. There was never a compliant bid. In fact, because it was always conditional. So it does not even cross the threshold. So I don't know whether before us there has been this position that there is an attack against the transfer of shares. I believe I asked Mr. Datterdin and he accepted that that was not a matter that arose before us, which it does not. And I think he has conceded that. So that's not, I don't see that they have shifted to that point. In fact, I think they have conceded that that is not a point before us, unless I have misunderstood.
What they might be saying, Your Honor, what they are saying is that the request for proposals process was brought to an end by this transfer of shares. I don't know if they're saying that or they're implying it. But the request for proposals was never brought to an end, and therefore it doesn't appear anywhere in the record that someone said that we're going to bring this request for proposals to an end. What happened was that the case stopped it. A case was filed 13 days after the bid was put in by Cara, and that is what stopped it, because there was an injunction. There were allegations made against the receiver, and that process must have come to an end. It came to a stop, but not to an end, until the case was being heard and determined. So that is what happened. The request for proposals process was never formally brought to an end, and so there could be no notification of it to anyone that we are bringing it to an end.
And that's your simple answer, isn't it?
That is my answer, Your Honor, to that. In saying this, I moved ahead.
Can I just ask, what happened to the injunction?
Pardon me, sir?
What happened to the injunction?
Well, the injunction...
Because the injunction was until determination of this cause. Usually that means that once you hit the trial, then unless at the trial in the hearing, unless an order is made, the injunction ceases, right?
Yes, it was not made permanent, so it came to an end at the end of trial.
So therefore, at the end of the trial, the injunction vis-a-vis the RFP lapsed.
Yes, Your Honor.
Was there anything preventing the RFP from being continued and dealt with?
This would have been 12 years later, and I suppose if Cara were interested in moving ahead with the RFP, they could have said Mr. Ram's tenure would have come to an end in 2003. They could have approached the Bank of Nova Scotia or someone, Hotel Tower, to say, we want to proceed. But I don't know if it would have been possible to do so at the end of the trial. Having a case, the issues are still live 25 years later. It has not come to an end, really, because the issues are still live, as we can see. We're
But
still determined.
Mr. Rampran, could the RFP process continue after Mr. Ram's appointment came to an end in 2003?
I don't know, because his receivership came to an end when I'm assuming that what the agreement says, the agreement of 19th of May 2003, says that this is what is going to happen in respect of the debt. I'm assuming, though I do not have the facts, that the debt was paid off, and I believe that the agreement also said that the receivership will come to an end on the payment of the debt. So that receivership would have come to an end. And when the receivership came to an end, there being no further debt, there would have been no need to
trying to find, right, around paras 32 and 33. It appears that the bank submissions is that there is a distinction between the public tender process and the private tender process. You end by saying Chief Justice Chang was right to find that any additional duties owed by public bodies did not apply to private commercial parties whose duties lay to the commercial purposes under which they were acting.
Yes,
I
Your
just want you to clarify, as a matter of law, if you think that a process contract could arise in the context of a private tender process. So I understand what the submission on the facts is. I'm asking, as a matter of law, if your submissions here are suggesting that a process contract involving a duty to act fairly couldn't arise in the context of a private tender process. Thank you.
Your Honor will note that I have not referred at all to process contracts because in my submission, Your Honor, it doesn't arise on the facts of this case. And I believe that while it is nice to discuss these principles of law, our duty here is to apply or to raise only such principles as can apply to the facts which are proved in evidence. And the evidence does not reveal any sort of process contract. But if I were to go further to answer Your Honor, I would say that the only thing possible would be something like what happened in the Blackpool case in particular circumstances which do not exist in this case. The Canadian cases with process contracts and Turcon were on fundamental breach of contract. Canada went a different way in terms of fundamental breach of contract. And we cannot simply pluck principles out, in my submission, Your Honor, and apply them to our facts without holistically knowing what the entire process, what was happening there. In England, fundamental breach of contract has been treated differently, and this court has dealt with fundamental breach of contract in Blairmont Rice and Cayman Sankar recently in 2021. So this court has gone, and Guyana, because it was a Guyanese case, which is binding on the Guyanese courts, has gone in a different way. So I don't know that we can look in a vacuum when it does not apply to the facts of this case to discuss process contracts. In respect of the public law aspect, public law, private law aspect, Your Honor, I would say that public authorities, which all of these cases were concerned with, Blackpool, Turcon, public authorities have more duties towards the public, have to be held to a standard of good governance, of their fiduciary. Private commercial entities who are looking towards their commercial purposes. In this case, both Cara and the receiver were looking towards particular commercial purposes. Those were their aims. Whereas as between a public authority and a bidding individual, different considerations apply. I don't know if I've answered, Your Honor.
I think I'm clear on your perspective. Thanks.
Very good, Your Honor.
Mr. Ramkaran, on that point, we know the case Spencer and Harding that talks about bids being a process contract or contract A is separate from contract B. When we think about public policy, is it all right in this day and age to say it's up to the commercial world to determine what they want to do, to parties making a bid and the other one deciding whether or not to accept, and leave it at that? Is there something to be said that in the commercial world lies a lot of impulses for inequality in society? I might decide you respond to my bid. So, well, you're not a member of my lodge, so I'll give it to him who is. Or you go to a church or mosque or synagogue that I don't go to, or I don't like this color of your skin, and all kinds of other reasons. So yes, you've entered the bid, I have a right to accept it or not, and that's that. Can we leave it at that in this day and age?
Your Honor, this subject is ripe for a ruling by this apex court, but not in this case. The right case will come along, and Your Honors will set it right. In this case, the circumstances don't exist. The circumstances do not require you to consider whether such principles should be applied. Because in this case, Your Honors, it is my submission that there was no contract whatsoever. And so if Your Honors agree with me that there was no contract whatsoever, Your Honors don't have to go any further. And in a particular case where there is such facts as in Blackpool had very clear wrongdoing where they did not allow, they said that you could bid, you put your bid in the right, and then said we're not going to consider it. In Turkon, they said only these 6 people we're going to be dealing with. You brought someone else in and they dealt with you. So these are very clear situations of what we could call wrongdoing or a wrong situation, an incorrect situation, which had to be corrected. But in this case, it is my submission that there was never any contract, Mr. President.
No, I'm very interested in what you're saying. Can you be clear with us as to why you say there was no contract in this case?
Your Honor, well, the first thing I will say is that no contract has ever been identified by the appellant. We don't know on the evidence where the contract is, what the contract is, what are the terms of that contract, what is the consideration for that contract, what exactly is the contract. An offer was made, which was not a complete offer. It was an offer which depended on certain due diligence requirements that had to be fulfilled by Cara. So they made a conditional offer to the receiver, and they said, we require until the 16th of February, I believe it was, to let you know. There were other conditions. Justice Jamadar raised those conditions, I believe, or it was Justice Ononewu, raised those conditions in the document, the bid document, where they said, before we can be your selected investor, we need to do these other things. There are no clear terms which we can point it to say that this was the contract. But if it was a contract to consider the proposal, the evidence shows clearly that Mr. Ram did consider the proposal. He wrote letters, one letter on the 19th.
You're now going on to suppose that there might have been a contract.
No, sir. I'm saying that there is no contract. But if it is that they're saying that you had to consider our proposal.
Yes.
He did consider the proposal. He did consider the proposal by...
But where would be the source of the obligation to consider the proposal? What is the source of that obligation? Is it contractual or is it something else?
No, sir. As a matter of fact, I'm saying to Your Honor that
Right.
there is no contract whatsoever because we do not know, we cannot ascertain what that contract is. What is the consideration for the contract? We don't know what are the terms, what are the obligations of the parties. We don't know what any of that is. But as a matter of fact, whether there is or is not a contract, my submission is that there is none. Whether there is or is not a contract, as a matter of fact, Mr. Ram considered the proposal. So we cannot say...
So that's a reserve argument you're making in the sense that assuming we disagree with you, that there is no contract, assuming we do find that there was.
I wouldn't put it that way, sir. What I'm saying is that you cannot say, you can never say that Mr. Ram did not consider the proposal. It is not possible for you to say so because he did. He did. He wrote letters to Scotiabank on the 19th and 21st of January 2000 saying, this is what I have, this is what they are, I'd like a meeting to discuss them. So as a matter of fact, he did consider what was put before him.
So you would then disagree with your senior. I don't want to sow division, but it seems I have to, because your senior took a very different approach, if I understood him correctly, and was asking for this court as the apex court to provide guidance on how these kinds of matters and these processes ought to proceed. So is there no value in the court providing that kind of guidance?
Your Honor, I have seen many decisions of this court where they say, these are wonderful propositions, but we will wait until the right case. This is not the right case, for Your Honors, in my submission, to give guidance on these issues, because to do so would be to venture into a sort of academic area where we do not have the clear evidence, as in Blackpool, as in Turkon, of something wrong, which requires Your Honor's intervention to clarify these principles.
But Mr. Ramkaran, here we are, 25 years after a case, don't you think clarity might have helped
Well,
in
Your
not
Honor,
having a case last like jaundice and jaundice? I don't know if you remember that from Charles Dickens' book, Bleak House.
Your Honor, the case had no legs to stand on 25 years ago, and 25 years later, it has no legs to stand on. We are here 25 years because of Cara. Cara should never have brought this case. This case was precipitous. It was not ready. If Your Honors look at the timeline, the proceedings were filed before anything could be done. Mr. Ram got the submission on the 12th of January 2000. He sent off to Scotiabank on the 19th of January 2000. The case was filed on the 25th of January. If you look at the injunction, Your Honor, the injunction is based on hearsay. It is Mr. Johnny Carpenter told us that this is what was happening. When Johnny Carpenter came to give evidence, he said no such thing. He said no such thing. This case was filed when there was no reason to file it. Had it gone through, but Cara was anxious that it should get this contract to run the hotel.
Mr. Ramkran, I just want to pursue an area of uncertainty I have. So Scotiabank in its submissions is very clear that the case was filed prematurely.
Yes, Your Honor.
Also clear that part of the reason for that is that the very conditions which were laid down by Cara in its offer, there would have been no opportunity for those conditions to be fulfilled because the very timeline that had been set for the conduct of due diligence would not have passed.
Yes, Your Honor.
What I'm just trying to get clear is whether the bank's case that there was no contract, process contract, is largely a function of the bank's view that no compliant bid had been submitted.
Yes, Your Honor. So there was no offer. We cannot arrive at a process contract unless we have something.
If a different view were taken as to whether the bid was compliant, is there anything in this factual matrix you think that could give rise to a process contract? I'm trying to figure out if the core submission relates to the bid not being compliant. So what if the
Anurin Bevan, which said that this has to be very, very carefully looked at to arrive at whether there is an implied contract or not. So the judge said contracts are not to be lightly implied. He set out 4 conditions. It will not be implied unless the facts show that both parties intended to create contractual relations. And in this instance, we would have a difficulty because what are the contractual relations that the parties are intending to create?
What's the point of asking somebody to pay?
Pardon me, Your Honor?
What is the point of asking somebody to pay a fee?
$18,000?
$18,000. Even if it's $1, it doesn't matter. What is the point of asking someone to pay $100 US towards a bid if you weren't intending to create contractual relations?
If I can speculate, Your Honor, I believe that it was to use the document room. So they would have had to go through expense to make copies of these documents, set up the room, put them there. So you paid a fee to see the documents, access all of these financial documents and everything about the hotel, so that you could see it costs something.
Why is that? Why would you want to have people come to a room and then look at something, assuming even that there may be instances where the bidding fee may be more than the token amount.
Yes.
There may be instances where it can be quite significant. But let's leave that aside. Let's take it at your argument that it's an administrative fee to provide a room. You have to light the room, air condition the room, and all that stuff.
Yes.
Leaving it at that.
Put people there.
Put people there. What's the point of having somebody go there and do that, setting up that system for somebody to go and look at the documents if you're not intending to create a contractual relations? No, contractual relations, sorry.
But what would be those what would be the extent of those contractual relations? the document, the request for proposals document. If that is so,
That's the point about whether or not you have contract A or contract B, isn't it?
if Your Honors, and I do not, I am only saying it for the purposes of argument and not accepting it. If Your Honors were to find that the request for proposals was a contract A or an implied contract or a process contract, however you want to term it, I would argue that everything in that contract was either met or what was not met was not the subject of the challenge in this case. So I would say that in order for us, for our legal system to operate properly, you must put what your problems are in your case, and you must lead evidence on those issues so that the court knows what you're saying in the first instance.
The president was asking you to react to what Mr. Boston had said about giving guidance to the jurisdiction, possibly the region. Is it beyond contemplation to say, and this is an argument, that's not a question to you, not a view I'm giving you now. Is it possible to have a scenario in which a court of law might say, yes, as a matter of general principle, these are principles that can guide this sort of thing, but in this case, the facts do not support fighting that those principles come home?
I think, Your Honor, that we were in that situation because the court of law did do that. It was completely unnecessary in my submission for Chief Justice Chang to speak about. He went off on a tangent to say, no, you don't have any contract, but you might have had this other contract, but you don't have this other contract. And this is where this idea came up. So if...
But it is up. It is with us now.
It is with you now.
Maybe it shouldn't have come up. We could talk about that, but it came up. So what I'm trying to figure out is, what is your objection to the route just outlined by my brother? Because the case is moving at two different levels. One is the general principles, and then one is the application to the facts here. And in applying the general principles to the facts, you might find that there was not, for example, a process contract. But we could certainly outline the components of what that would look like. What I'm trying to find out is, what is the basis of your objection? Is it that it's not an issue in this case? Is it that you have not had the opportunity to think about it deeply enough and to cite authorities? Is it that other authorities are being cited by other persons that you have not had a chance to consider? I'm trying to understand the reluctance you have for us to provide the guidance that your senior thought we should.
My objection fundamentally, Your Honor, is the application, the use by counsel of principles where the facts do not lead to the application of those principles. The facts cannot hold it up. Like, I can use a bread baking analogy. If you don't put enough flour into your bread, the bread will fall flat. In the same way, if you don't have the facts, but you have the principles, the case should fall flat.
But Mr. Ramkaran, when we say what are the ingredients for baking the bread,
Yes.
and we set those out, then we look at what we have been given and we say, oops, there was no flour.
Certainly.
So you can't bake bread. But we must first know what are the ingredients to determine whether we can bake bread or not.
I understand.
So you are putting it the other way.
I understand, Your Honor's...
So how do we, given everything that has transpired before us today, including what your senior has submitted to us, how do we not address this issue, albeit we may end by saying exactly what you say on the facts?
I understand Your Honor's concerns very clearly, and far be it from me to tell Your Honors how your decisions should go. All I am saying is that in this case, there is no process contract or implied contract. Your Honors are free to say where there are process contracts, these are the principles which apply.
We don't want you to concede so easily. Because we could be persuaded by you. We could be persuaded that this is not an appropriate occasion to...
I do not believe it is, Your Honors. I do not believe it is.
Yes, but I'm trying to find why you don't believe it is. Because, you see, if you're saying to us that, look, I have not had a chance to consider all of the authorities, you know, my opposite side, they've cited cases that I've not looked at, etc. I could understand that. I'm not saying necessarily agree with you, but I could understand that. But all you seem to be saying is that this is not the right case, and I am a little bit hard pressed to understand exactly why you take that view, especially in light of all that has been said
Your
before.
Honor, in my submission, the circumstances that existed in Blackpool and existed in Turkon do not exist here.
Right.
So it is, in my view, therefore, not an appropriate case for the discussion in the abstract of principles which could apply had those circumstances existed.
Do you think we are in possession of the relevant information, the learning, the cases, and so on, that we could make, a fair go at providing that general guidance that Senior wanted?
Well, I have a great deal of faith in this court, Your Honor. I know that
We're glad to hear
you
it.
know what the right principles are.
Okay.
And so,
All right. Thanks.
I think I've set out my submissions, other than to say that the evidence of Paul Stevenson and Johnny Carpenter did not show any evidence of wrongdoing on the part of Mr. Ram. If you look at the evidence of both of those gentlemen, you will not find anything to show that any of the allegations which were put forward against Mr. Ram were established. So it is my submission that no wrongdoing has been proved on his part. Although an injunction was sought and obtained on the basis of this wrongdoing, which lasted for over 11 years, preventing the receiver from doing his duties to recover the debt of the bank, which increased every day on the basis of the interest that was accruing, and which was not a good use of the justice system. And I hope that if Your Honors are saying things in your decision about what should have happened, that this is something that
Could have been abbreviated, aborted.
Your Honor, I would start by saying that the situation which caused this to happen does not exist, or does not exist. Most of it does not exist anymore. It happened because of the old rules, and when you put a matter, when you requested hearing in a matter, it took 8 years to come up for trial. We've all gone through this. Every person in this, all of the lawyers have gone through having their cases requested for hearing and then waiting 8 years for trial. I think this is about the same. It might have been a little more. And then when the trial comes on, it takes another 3 years for the case to finish. And when you get to the Court of Appeal, there is again a backlog. I understand the backlog now in the Court of Appeal is about 2,000 cases, 2,500 cases. So there are cases pending in the Court of Appeal for 10 years, 8 years, 12 years. Now, Your Honors will see them come up. And so this is the situation where there is no system of case management. The new rules were not yet in force, which move matters quickly. A case filed now takes 1.5 years to finish, which is quite reasonable. It comes up right away. It's moving all of the time. So that will never happen again in the High Court. But in the Court of Appeal now, the cases go and they sink there. And until new rules and a new Court of Appeal Act comes into force, case management is brought in, that situation will remain the same, where appeals languish for years and years. But you have litigants using the system, getting injunctions which they should not get, and in this case, what happened was it must have caused severe distress to the bank to have that debt piling higher and higher by the day, and nothing could be done by the receiver to deal with the request for proposals, unless he risked breaching the injunction.
It really is a very serious issue. Without commenting on the merits of this particular injunction, I mean, you can imagine the effect of it from a macroeconomic point of view. It's devastating.
I will tell Your Honor, when I came into practice, around the same time as this case was filed, the interest, I used to work for banks and still do, as Your Honors can see, the interest for commercial loans was 19 and 22%. When I was seeking judgment in what was the equivalent of commercial court, the interest was 19 and 22% because banks could not get back the money. They couldn't get, so it has an effect on everyone. People who want to get loans could not get loans because of the effect that the cases, you couldn't get money back that was lent. So it has a huge effect all around the society when the court doesn't work the way it should. So if I could move on, Your Honor, to the effect of the decision of Justice Moore. Your Honor, that decision is clearly interlocutory. And there is authority, which I've cited, is Hunt and Allied Bakeries, where it was said in that case by the Court of Appeal of England and Wales that an application to strike is an interlocutory order. And in Vehicles and Supplies Limited, Your Honors, which I've also referred to in my submissions, the House of Lords, Lord Walker of Gestingthorpe says, no estoppel per rem judicatum arises from an interlocutory order. So in addition to the case which Her Honor, Justice Onanaiwu, referred to, cited by my friend, says that it only applies to a final order. It is quite clear that an application to strike out is an interlocutory order. Justice Moore went through the principles where he said, I can only look at the statement of claim. So he made his determination on the basis of what was set out in the statement of claim, not on the basis of any evidence. And it was no barrier whatsoever to Justice Chang. Your Honor,
So he assumed that the facts stated there were actually correct. And
Yes,
that's the
yes,
basis
Your
on
Honor.
which he acted. Okay.
and in any event, he could do nothing further. There was no evidence before him. This is not an issue of jurisdiction. This is not a decision which could bind the trial judge. It would make sense, in simple common sense, to arrive at that conclusion. But there is authority for the fact that it could not be res judicata in any event. Your Honors, I believe that I have gone through all of the things I wanted to raise with you, unless there are any questions which I can assist you with. The claim is $14 million when Your Honors are considering costs. $14 million US dollars, as conceded by my friend earlier this morning.
We understand your submissions. I think we have no further questions for you, Mr. Ramkaran.
I'm very grateful,
Thank you
Your
very
Honor.
much indeed, sir. Thank you. Mr. Dantadin, before you begin your response, or maybe during or at the end of it, could you address us on the last point made by Mr. Ramkaran having to do with costs, please?
Your Honor, cost should follow the event. Simply, cost should follow the event.
Okay.
Your Honor, what is being said by the respondents, if I may, is that there was an injunction that stopped the receiver acting. That is not true. The injunction is exactly the opposite. Obey the RFP. He chose not to do it. If he wants to hide behind it, then that's a different thing. But this court must see through that. The injunction didn't stop him. The injunction said follow the RFP. Then he was involved in what he should not have been involved in. He subverted it. So for the bank to cry crocodile tears to say they had to wait for 11 years until it was done, they sold the assets within 2. The bank as well chose not to follow. They appointed a receiver. They knew there was an order that he should follow the RFP.
Mr. Ramkaran, Mr. Dodson, Mr. Ramkaran was saying, why didn't you bring a motion for contempt of court?
Your Honor, that respectfully, a motion for contempt of court, if he is not following the order to deal with the assets, Your Honor, that's because respectfully we are of the view that the shares are not assets. And there would be, strictly speaking, the contempt being pseudo-criminal, what has to be proven is exactly a breach. But they well knew what was being done by simply selling the shares. What is it about selling the shares to the shareholders? He is a receiver.
Sorry, do I understand you to be saying then that you're saying that there was no breach of the order then?
No, not for contempt to be had, no. And no, to answer simply, shares are not assets. Now, Your Honor, I got sidetracked a little bit from when Justice Jamadar indicated to me about the Court of Appeal proceedings. Your Honor, there were two things that I think that I would like to highlight about the Court of Appeal proceedings. It's in the speaking notes we filed to raise. The application of the test of intention to create legal relations. Much has been said that it is for Cara to prove that there is the intention to create legal relations and there is a contract, as has just been advanced by my friend Mr. Ramkaran. Your Honor, that's not what the law is. The law is in all commercial activities, it is presumed that there is an intention to create legal relations. That's why commerce exists. The fundamental reason for commerce is to create legal relations. And when you do, that's how you do business. It is for the party who is alleging that there is not to establish that when they advertised, when they asked you to sign a confidentiality agreement, when they asked you to pay to use a document room, when they asked you to submit a request for proposal in a specific form, format, and time, that was not to create legal relations. How could that be treated that way? And then the submission that this does not fall within a legal problem or a legal issue, and none of the process cases, which are what the Australian and New Zealand cases say, versus the contract A-B when you deal with tenders. Your Honors, if you advertise for tenders and the persons advertising or seeking the tenders was simply allowed to go silent, receive tenders, do nothing. In Guyana now, there are about 100 tenders a week on government contracts. And if what you were entitled to do is simply sit back, receive the tenders, do nothing, award it in whatever way you choose, say it's an emergency provision, say you're sole sourcing, all of that, it would subvert the entire process of tendering. The second thing we would respectfully ask the court to consider.
Quickly, Mr. Dutton, the statistic that you cited related to the public procurement process, any difference with respect to what should apply in the context of a private tendering process?
Absolutely not. Okay. He put it in an advertisement in the papers. He's asking the whole country, the whole world, tell me if you're interested.
Well, Mr. Dutton, stop. Hold on. Under a public procurement process, there's statutory underpinning that governs rules, regulations, standards, and so on and so on.
Yes,
so I don't think you should be so cavalier to say absolutely not.
I take it back, Your Honor.
Just be a little
we
more
have
precise.
We have an act in Guyana for public procurement that is that regulates every aspect of it. It is not the same. But, Your Honor, the attitude of the person receiving the tender and his obligations on how he treats with what he receives are identical. And again, we come back to the Borganza principle about the reasonableness. Because you have the right to terminate doesn't mean that you terminate and you don't say anything. Notice this, and it's important, Your Honor. We heard that there were 6 bidders, 5 more bidders. We had no evidence of any communication going to anyone to say this is the outcome. We had no evidence from Mr. Ram as to what he was doing. He said stopped.
But everybody knew that there had been a restructuring.
Your Honor, in a system where it takes 25 years for a case to be heard, most people choose not to get involved. That is the truth.
And the reason I'm asking that, everybody knew, would it be correct, your clients knew that in 2003, there was a corporate restructuring agreement that basically
There was a sale of the shares. Yes.
Yes, that to go purpose out of the bidding process, if it still existed. How different is that from you apply for a job and there's only one job? You hear nothing, but then next thing you hear is the announcement of somebody else who has been given the job. Do you have a right to sue because you were not told, sorry, we did not accept your application? Is there a
Your Honor,
difference?
No, you wouldn't have the right to sue, but it's slightly different, please, Your Honor. When you invite the bids, and people have put effort into doing the bids, they
Same
have...
thing as a job application.
But Your Honor, you don't do
vacancy
all.
announcement.
You don't do all of that, and there is no obligation to consider and to do as would be in this request for proposal. So within the confines of the request for proposal, Mr. Ram said he was bound. And Your Honor, the case of Edwards and Skyways is very clear about intention to create legal relations when you are the person doing the commercial activity. Then the satisfactory due diligence argument to say that there was no bid submitted. Your Honor, the obligation of procedural fairness is very simple. Every bid that you receive, you must pronounce on. You can take it and say, well, you haven't complied with the rules. You are not a compliant bid. You have not done. But procedural fairness requires that if it is defective, you take it in and you say it is defective. What happened here was total silence. And what is being hidden behind is that the injunction stopped it. That is not true.
We have covered that point, Mr.
One other aspect that
Yes,
we
I
wanted to
may
raise.
suggest that we will stop at 2 o'clock, so you have about 7 minutes at most. Yes.
Your Honor, subject to how I've put this together. So, Your Honor, we're back to the last thing we were speaking about, damages. Your Honor, in the submission, in the record at about page 224, there is the detailed of what was submitted in the courts below and about damages. But Your Honor, having regard to what was said this morning and having regard to the submissions to, especially from Justice Jamadar, Your Honor, I would respectfully submit as follows. What would be the entitlement would be this. It is breach or the breach would lie insofar as it relates to contract A, not to the full value. And the measure of it from the authorities that are mentioned there is the probability of success versus what would be the annual profit, for example. And the cases do bear out that position.
Mr. Boston says you're taking a knife to a gunfight.
No, please, Your Honor. Respectfully, the gun lies the other side. What the bank and the receiver are doing is trying to hide between things of reasons why the receiver has not done his job. But what he should do is the other side. Sorry, Your Honor. He could say game over. He was entitled to say game over, but he didn't. He sat back and he did nothing. He, in fact, engaged in a process that is parallel, alternate, and defeats the entire court process when he is a party to the court. And, which I said at the very beginning, by being appointed by a judge, he was an officer of the court. And if he was not going to carry out his functions, he should have informed the court. He had an obligation. He was not only appointed by contract. But, Your Honor, at page 464 of the record, there was submitted with the proposal, the bid proposal of Cara, the profitability and the annual profits. There are ones that were put into the RFP. The annual profitability, the annual figure of a profit is, which was in the evidence of Mr. Stevenson as well, said that over a period of 10 years, it was approximately $9.4 million US. So if you divide that by 10, it would be approximately $940,000 a year would have been the profit. The chance, if we take the letter that was written, that was produced only at the trial in the High Court, that it was one of 5 bids that had been submitted.
Profitability,
Yeah.
can you...
Projected, it was projected profitability.
How is that speculative?
Pardon?
Isn't that speculative projection?
Oh, yes, it is, Your Honor.
And
But
hold on, as I asked Mr. Boston when he was on his feet, the hotel had been losing money for 8 years before the receivership.
Yes,
had
yes,
it was in dire straits.
yes.
Where do we get this projection of profitability for a company that was not able to pay its debt, so it went into receivership?
So, Your Honor, what happened is Mr. Ram, as receiver, said these were the improvements that were done, these were the projections that were done, these are the things that you could use to submit your bid. Cara took the information. There was a gentleman who gave evidence, who is a certified valuation, somebody who can do those projections, and he did that projection. That was submitted to RAM, and that's part of the record at page 464. And what we say, Your Honor, so there's a 1 in 5.
Just cut to the chase, though. I mean, Mr. Boston is saying you didn't have a chance because your bid was so very low as compared to the others. So where do you get the chance from?
Your Honor, that was precipitate, and I tell you why it was. It was this. There is in this bid from GBTI Bank a guarantee about the bid. But, Your Honor, it comes down to the same probability.
But
the probability is, if I may, Your Honor, 1 in 5. So if you're to divide it, that comes up to about, my maths is not very good at all, but it would be approximately, that would then be $180,000 per year. I know the court has a view about speculating across very long periods of time and whether that would be. And then the court could make an appropriate adjustment for what it thinks would be reasonable.
I think I'll have to adopt Justice Jamadar's terminology and refer to your formula as the data-in formula.
You know, no, Your Honor. This is actually what the cases that are mentioned on page 224 of the record do say.
We'll have a
This,
look at.
this is, and in all those cases, there were different percentages allocated, and you could see at page 224 where we mentioned some were 10%, 15, 20, 30. It was based on what the court considered to be the possibility. So Your Honor, we're not trying to say that. We say that we take it from the position that there were 5 bidders. So there was there were 5 total. So there was 1 in 5. If it was 6, it would be 1 in 6. I know the court wouldn't want to necessarily go for 25 years because the court in original jurisdiction matters, the court has said that there has to be a cutoff. This is in the Guyana case with the recovery, that there must be a cutoff. I think at 10 years, the court had indicated that would be. And that, Your Honor, would be the measure of damages. Yeah. Because what it would be is there is a breach of contract, so respectfully, Your Honor, there would be, that would be the measure of damages. Your Honor, there was only one other thing I wanted to mention. A lot is said, or a lot is being suggested about the receiver or his hands being tied and he didn't do anything wrong. Your Honor, he gave evidence in the court. And he said the reason he did not do anything was because he gave an undertaking to the court, but he could not produce an undertaking to the court. And the only order as it related to his conduct was Jainarayan Singh J. order, that he follow the RFP. So he can't say he didn't understand legal relations also were going. The people came and took you to court to compel you to follow the RFP. You must at that stage realize that your duties and obligations must lie under that RFP. Yeah.
Did you find out whether you had prior knowledge?
No prior knowledge, Your Honor.
By the
no.
others? No,
it came up, that letter was produced when the bank gave evidence before Justice Chan.
That's when you found it.
Not from Ram. Ram didn't produce that letter to say that that's what he did. The bank, in coming to give evidence, produced and said they had received that letter.
Okay. Thank you, sir.
Thank you very much, Your Honor.
Well, I've looked around at my colleagues, and I don't think we have a decision for you just yet.